I will say that is directly in response, Mr. Goff, to statements you made, which I find reprehensible. The Colonel Sanders statement you made last week, I would suggest maybe something that has influenced what is going on here. In response to that, and to his credit, Mr. Sheffield made some comments, but did say, come one, come all. And so now the court is faced with balancing a lot of things going on outside this courtroom and doing it in a way that respects members of the public's right to be in the courtroom, as well as what I'm trying to put out there is a fair trial, right? So you need to understand, everybody, that your words in this courtroom have an impact on a lot of what's going on. And so my measured response at this point is to balance all of that out and try to move forward with the trial. I'm not granting a mistrial at this point based on these arguments that are being made, because I think I'm not granting a mistrial at this point based on the arguments that have been made. Are we ready with the witness from the state? Be Mr. Sheffield.
Okay, there you have it. Judge Walmsley listened to the arguments there. Extraordinary morning there in Glynn County. We're bouncing back and forth between Kenosha, Wisconsin, where we are now, and that what took place in Glynn County. The bottom line is the defense wanted a mistrial because of the presence of Jesse Jackson, then a small outburst, if you will, in the gallery. They claimed that jurors looked to the family and they saw Reverend Jackson, saying that that would constitute a mistrial. As you heard it there, the judge said no to that. Now, Kenosha, Wisconsin, Judge Schrader still reading those ever important, always important jury instructions to the jury. We'll slip in one break, and when we come back, we'll have the closing arguments in the case against Kyle Rittenhouse. Stay with us.
What if the news was different and covered more than one side of the story?
Justice wasn't served.
So you can make up your own mind.
I love this so much.
Introducing the new point of view. Yours. Newsy. Watch free 24-hour news.
What if there was a show that connected the dots by offering different perspectives? What if primetime news skipped the talking points and focused on the issues y'all might want to hear?
People around the world have been hosting their own virtual weddings.
No matter how weird. Join me, Christian Bryant, for a different kind of nightly news show. In the Loop, weeknights at 9/8 Central, only on Newsy.
This is true crime all the time.
We continue our gavel-to-gavel coverage.
We are live in courtrooms across the country.
This is what I love to do.
Travis and Gregory McMichael are charged along with their neighbor, William Roddy Bryan, in the shooting death of Ahmaud Arbery.
We are all too aware how high the emotions are running.
Every moment of that video is expected to provide key evidence in this case.
Those facts will be revealed where all facts that matter are revealed in a courtroom.
It's time to see the bigger picture, widen the lens, narrow the divide. It's time to ask, why? Introducing a new point of view. Yours. Newsy. Watch free 24/7.
Welcome back to Court TV Live. I'm Ted Rollins, live in Kenosha, Wisconsin. Judge Bruce Schrader is winding up his instructions to the jury before closing arguments. Let's listen in.
For great bodily harm was unreasonable and substantial, and that he was aware that his conduct created the unreasonable and substantial risk of death or great bodily harm. Great bodily harm means injury which creates a substantial risk of death or which causes permanent serious permanent disfigurement, or which causes a permanent or protracted loss or impairment of the function of any bodily member or organ or other serious bodily injury. Third, that the circumstances of the defendant's conduct showed utter disregard for human life. In determining whether the circumstances of the conduct showed utter disregard for human life, you should consider these factors: what the defendant was doing, why he was doing it, how dangerous was the conduct, how obvious was the danger, whether the conduct showed any regard for life, and all other facts and circumstances relating to the conduct. If you are satisfied that all three elements of this offense have been proved beyond a reasonable doubt, and that the state has proved beyond a reasonable doubt that the defendant was not acting lawfully in self-defense, then you should find the defendant guilty of reckless endangerment of the first degree as submitted. If you are not so satisfied, then you must find the defendant not guilty. You are not in any event to find the defendant guilty of more than one of any sequence of offenses. So you can return only one verdict per count. You should consider the charged offense first. If you find unanimously that the defendant is guilty of the highest degree of crime, you need not consider lesser included offenses. If you decide unanimously the defendant did not commit the greater crime and was acting lawfully in self-defense, I've got myself into a mid-sentence and I don't like it.
All right, calling the defense attorney, or all the attorneys at bar, because Judge Schrader kind of worked himself into a corner in his instruction there, and he's just looking for acknowledgement from both sides that as he was likely ad-libbing a bit with the jury instructions, wants to make sure he does not, he recover properly and doesn't create something that could later come back to haunt the case. C.K. Hoffler with us. CK, jury instructions, they are extensive. Jurors pick up some, not all of it, but they're important because that, at the end of the day, is a map, is it not? Guidelines for the deliberation process.
Absolutely, Ted. And the jurors will have a copy of the jury instructions. At least that's usually the way. It's not unusual for a judge to not like the language midway and to break and to consult with counsel, because every single thing in this case is likely going to be challenged on appeal if there's any aberration. So it's good, actually, that the judge said, don't like the language, let me consult with the lawyers to get it right. But the jury instructions are roadmap. The jurors will take the jury instructions with them and be able to analyze the evidence in the context of the law, which is what the jury instructions will give them.
All right, you can see that the judge is sending the jury out of the room. This is going to be a little bit longer discussion to make sure everything you know, it's a high profile case, and he acknowledged it today that everything they could do to make it right matters. So let's do this. We'll take a quick break as well and get you back into the courtroom as soon as we come back. Closing arguments expected soon in the case against Kyle Rittenhouse. Be right back.
What do you think the future looks like?
From Newsy, renowned journalists and filmmakers, comes a celebration of storytelling.
Are we in a killer robots arms race right now?
When the suspect admits to it.
I'm not going to argue the law with you.
New features every week. Newsy Docs presents Sunday nights at 9/8 Central, only on Newsy.
What if the news lets you see, hear, and think for yourself?
We are at the absolute dawn of this, of seeing where this goes.
Introducing a new point of view. Yours. Newsy. Watch free 24/7.
Captures the essence of what Vietnamese cuisine is.
Breaking news in the case against doomsday prophet Chad Daybell.
Prosecutors say they will seek the death penalty against him.
Investigators have recovered human remains at Chad Daybell's residence.
There's no way, Morgan. I should never come up with this.
All eyes on this Idaho trial.
Will his wife, Lori Daybell, turn on him?
It's just so hard to know where the truth ends.
It's the doomsday prophet Chad Daybell on trial.
Free Movie Channel has something for everyone. Find your new favorite movie tonight.
Former Staff Sergeant, United States Air Force.
Sergeant, United States Marine Corps.
Petty Officer First Class, United States Navy.
Proud to support my husband, Sean, retired Master Sergeant, U.S. Army Special Forces.
To all of our veterans, we stand behind you and acknowledge the sacrifices that you have made. At Scripps, we strive to be an employer of choice for reservists, transitioning veterans, and their families, by offering programs for transferable skills. See where Scripps can take you.
Captures the essence of what Vietnamese cuisine is.
I'm Vinnie Politan. You know, I stood before a jury on both sides of the courtroom. First as a prosecutor, then as a defense attorney. But with CourtTv, you're the jury. You see every moment of testimony.
Y'all know I didn't do this.
Every story unfolds.
I'm sorry for my crime.
Until a verdict is rendered and justice is served.
The all-new CourtTv, your front row seat to justice.
It's time to see the bigger picture, widen the lens, narrow the divide. It's time to ask, why? Introducing a new point of view. Yours. Newsy. Watch free 24/7.
Welcome back to Court TV Live at our continuing coverage of the state of Wisconsin versus Kyle Rittenhouse. We are anticipating closing arguments in this case to begin in just a few minutes. Judge Schrader still talking to the attorneys outside the presence of the jury about the final count 5 jury instructions. They're going back and forth on the wording. Let's listen in.
They all agree that the elements are met and there's a privilege. You don't go any further.
Pardon me?
I believe the pattern instruction makes that clear enough.
if they can unanimously agree, which includes the privilege, they're done. They don't have to go forward.
Where does it use? It says you should make every reasonable effort to agree unanimously on the charge of second-degree intentional homicide before considering the offense of first-degree reckless homicide. However, if after a full and complete consideration of the evidence, you conclude that further deliberation would not result in unanimous agreement on the charge of second-degree homicide, you should consider whether the defendant is guilty of first-degree reckless homicide. So there, I don't think it's not the way a person would speak if he wanted to make things clear. And I'm not saying anyone deliberately is trying to make things unclear, but
I think one can say that about all 30-some pages of the.
Don't do that. People will find out our lawyer secret.
I think it's clear in the instructions. If the court did wish to make it clear, I would just say, just explain if you're unanimous either way on the first count, there's no need to go to the lessons.
Yeah, I think that's a good way to do it. I think I'll tell them that in any sequence, if there are lessers submitted to them, once they've discussed the highest count, if they are unanimous either way, then they're done. Does that make sense? No, Mr. Binger is having a problem with that, and let's see where he is or what he's. I don't like the way I said that either. How about this? In any count where there are multiple verdicts submitted to you, if at any point in your deliberations you are unanimous either as to both the elements, presence or absence of the elements of the crime, and the presence or absence of the right of self-defense, you need go no further.
The reason I was shaking my head, Your Honor, is because let's take Anthony Huber's counts, for example.
Yeah.
If the jury is unanimous that he is guilty of first-degree intentional homicide, they go no further.
Right.
If they are unanimous that he's not guilty of first-degree intentional homicide, then they are instructed to consider second-degree intentional homicide.
Only if they're not satisfied that it was done in self-defense. If they, for example, if in your example, if they discussed it and said, well, sure, the elements of attempt murder are there, and then they go around the table and they say, well, we all think it's not self-defense, then guilty. If they all say we don't think it's, well, actually, if they all say we don't think it's self-defense, then it's not guilty. And what the jury is being told is if you can't agree unanimously, then consider these lessers. But I don't think it's so clear as it should be.
It says if you are not so satisfied.
I know it. Well, that's at the very end.
And I think what the court was originally proposing is telling the jury that if you're unanimous on the charge count one way or the other, then you go no further.
I like that.
That's not the law.
If you're unanimous on.
So, for example,
if you're unanimous on the legal question, intentional, well, you're right, because it could be an elements issue.
The jury.
Maybe the constructions committee is right. I don't know.
The jury only goes to lesser included if they are either unable to agree on the charge count or if they're unanimous not guilty on the charge count. Then they go to the lesser included. So there is no requirement that they be unanimous on the charge count to move to the lesser.
No, they shouldn't be unanimous. If they're unanimous, then they're done. That's what I'm trying to tell them, but I don't know how to say it.
But that's not true, because if they're unanimous on first-degree intentional homicide, what they're concluding at that point is that the defendant, either the elements aren't met, or the defendant actually believed that deadly force was necessary. They would still then have to consider the second-degree intentional, because it changes the self-defense into the objective, reasonable one. So they can be unanimous on count one. Let's take Huber, for example. They can be unanimous on the first-degree intentional homicide. They can be unanimous on that, and in the defendant's favor. But they still have to then move to the second element, or to the lesser included.
You might be right.
Perfect self-defense.
Pardon me?
If it's perfect self-defense, it's perfect self-defense for everything.
But they're not told to consider perfect self-defense on first-degree intentional homicide. They're specifically told.
It's fine.
Well, yeah, you're right. He's right.
They're not told to consider that until second-degree intentional homicide. The instructions, Your Honor, are the pattern instructions. I understand your point that if we had to redraft them today from scratch, maybe we could do better. But I'm sure we could. But we need to follow them, and I don't think deviation is appropriate.
I think you're right. And they are certainly correct in what they say. I just think that they're not clear. But maybe they are. I don't know. Now let's see how much damage I've done already by my last paragraph. So can you go back to what the last thing I said to the jury?
All right, and Judge Schrader still working out the details of the final jury instructions before closing arguments begin in the case against Kyle Rittenhouse. We anticipate they will be moments away. Right now, we want to step aside, take a break as we approach the top of the hour. When we return, Julie Grant will be here. Stay with us. This is CourtTv, your front row seat to justice.
is in our network to find out if you could save on your prescriptions and to get our free decision guide. Humana, a more human way to healthcare.
Good Monday afternoon to you and welcome to Court TV Live, your front row seat to justice. I'm your midday host, Julie Grant. Two major trials we are bringing you today. We're in Brunswick, Georgia for the case of the three men accused of murdering jogger Ahmaud Arbery. The defense attorneys are arguing for a mistrial in that case based on the Reverend Jesse Jackson's presence in the courtroom. So we're watching this unfold. At the same time, we're watching the judge deliver the jury instructions in the case in Kenosha, Wisconsin against defendant Kyle Rittenhouse. And as the judge was instructing the jury, he abruptly stopped, called for a sidebar, sent the jury out. Let's go back in together live.
Whenever I've dealt with lesser included, I do give a little talk about how they should address them. And this is a more complicated case than most, than any, frankly, that I can remember. I don't think I've said anything incorrect so far. I don't want to step into something that I haven't already done. I am inclined, though, because I've made a statement about if everything's present, they're done because they found the defendant guilty. And I do think I probably should give the alternative, which is, and I'm not going to use terms like perfect self-defense like he did. I'm going to use the term acted lawfully in self-defense. And they're instructed on that. So I think the correct statement is, if as to any of the cases with multiple submissions, if on any individual count, they find in their consideration of the charged offense that the defendant acted lawfully in self-defense, they're done. Any objection?
No.
Okay.
While we're talking about the jury instructions, it was noticed as you read them on page 10, which is count 3, it should be first-degree reckless endangerment, and it's written and you read homicide, which it's not a homicide count. So
but on page 10,
top page 10 on count, still at the end of count 3, it says you should find the defendant guilty of first.
Yeah, you're right.
Homicide.
You're right. It is in there as homicide. We didn't catch that last night when we talked about them. I sent you 3 drafts. But you know what? Should I just leave that alone? They'll know that. I'll change it in the printed copy. Okay, thanks.
Are you anticipating closing before lunch now? It's after 11.
How long are you going to talk in your first sequence?
I'm trying to limit myself to 2 hours.
Are you troubled by taking a break in the middle of your presentation? Well, let's just kind of plan on around noon because the lunch has already been ordered. So, and I'm not going to comment on the lunch. So let's ask the jurors to come back in, please. So I'll take a break why don't you around whenever you're comfortable, around noon, just ask for the break. Yeah, well, when he's the commander of I don't want to interrupt him at a time he doesn't want to be.
Did you get my eye out?
I did.
There is Kyle Rittenhouse, the defendant in this case, 18 years old today. He was 17 years old at the time of this incident. This, of course, occurring last August of 2020. As this trial has progressed, we know that 2 charges have gone away, the last 2 charges. Let's listen in together now.
Multiple possible verdicts submitted to you for consideration. When you address the charged crime, if in your discussions you conclude that the elements are present and the defendant was not acting lawfully in self-defense, then you needn't go any further. You can return your verdict of guilt based upon that conclusion. If in your discussions as to any individual count of those with multiple possible verdicts, in your initial discussion, if you decide that the defendant acted lawfully in self-defense, you're done. And you can return a not guilty verdict without considering the lesser offenses. Any question about that? It hopefully will become clear. I'm going to give you written instructions because I know this is arduous going through this, but every bit of it is important. But you'll get written instructions for your reference in considering these things. Counts 1 through 5, that's all the counts now. Each contain the guilty verdicts of any submitted offense contain a question based upon the allegation of the information that the defendant committed the crime while using a dangerous weapon. If you find the defendant guilty on any of the counts, you must answer the following question. Did the defendant commit the crime while using a dangerous weapon? Dangerous weapon means any firearm, whether loaded or unloaded. A firearm is a weapon which acts by the force of gunpowder. Before you may find answer the question yes, you must be satisfied beyond a reasonable doubt that the defendant committed the crime while using a dangerous weapon. If you are not so satisfied, then the question must be answered no. In reaching your evidence, examine the evidence. In reaching your verdict, examine the evidence with the utmost care and caution. Act with judgment, reason, and prudence. The defendant is not required to prove his innocence. The law presumes every person charged with the commission of a crime to be innocent, and this presumption requires a finding of not guilty, unless in your deliberations you find that it is overcome by evidence which satisfies you beyond a reasonable doubt that the defendant is guilty. The burden of establishing every fact necessary to constitute guilt is upon the state. Before you may return a verdict of guilty, the evidence must satisfy you beyond a reasonable doubt that the defendant is guilty. If you can reconcile the evidence upon any reasonable hypothesis consistent with the innocence of the defendant, then you must do so and find him not guilty. The term reasonable doubt means a doubt based upon reason and common sense. It is a doubt for which a reason can be given, arising from a fair and rational consideration of the evidence or want of evidence. It means such a doubt as would cause a person of ordinary prudence to pause or hesitate when called upon to act in the most important affairs of life. Reasonable doubt is not a doubt which is based upon mere guesswork or speculation. A doubt which arises merely from sympathy or from fear to return a verdict of guilt is not a reasonable doubt. A reasonable doubt is not a doubt such as may be used to escape the responsibility of a decision. Examine the evidence and search for the truth, giving the defendant the benefit of every reasonable doubt. Evidence is defined first as the sworn testimony of witnesses, both on direct and cross-examination, regardless of the party who called the witness. Second, any exhibits which have been received, whether or not they accompany you to the jury room. Third, any facts which the lawyers have agreed or stipulated, or which I have directed you to find. Anything that you may have seen or heard outside the courtroom is not evidence. You are to decide the case solely on the evidence offered and received at this trial. You should disregard entirely any question to which I did not permit an answer. Do not guess what the witness's answer might have been, and if the question itself suggested that certain information might be true, ignore the suggestion and do not consider it as evidence. Attorneys for each side have the right and duty to object to what they feel are improper questions asked of witnesses and to the receipt of other evidence which they believe is not properly admissible. You should not draw any inference or conclusions from the fact that an objection is made. By allowing testimony or other evidence to be received over objection, I did not mean to indicate any opinion as to that evidence. You jurors are the sole judges of the believability of the witnesses and of the weight of the evidence. At the beginning of the trial, I described the charges against the defendant, counts 6 and 7, which respectively charged possession of a firearm by a minor and curfew violation, have been disposed of and are no longer part of this case. The other counts remain. Do not guess about or concern yourselves with the reasons for these dispositions. It must not affect your consideration of the charges that remain. Do not consider evidence that related only to the counts which have been disposed of. During the trial, I have ordered certain testimony stricken, and you must disregard all such stricken testimony. Exhibits become evidence only when received by the court. An exhibit which was marked for identification but not received is not evidence. Whether or not, is not evidence. An exhibit received is evidence whether or not it accompanies you to the jury room. Remarks of the lawyers are not evidence, and if the remarks suggest certain facts not in evidence, disregard the suggestion. You should consider carefully the closing arguments of the attorneys. If their arguments, opinions, and conclusions are not evidence, draw your own conclusions from the evidence and decide upon your verdict upon the evidence under the instructions given you by the court. I have taken judicial notice of certain facts, and you are directed to accept them as true. The state has introduced evidence of statements which it claims were made by the defendant. It is for you to determine how much weight, if any, to give to any statement. In evaluating each statement, you must consider 3 things: whether the statement was actually made by the defendant. Only so much of a statement as was actually made by a person may be considered in evidence. Whether the statement was accurately restated here at the trial, whether the statement or any part of it ought to be believed. You should consider the facts and circumstances surrounding the making of each statement, along with all other evidence, in determining how much weight, if any, the statement deserves. The weight of the evidence does not depend on the number of witnesses on each side. You may find that the testimony of one witness is entitled to greater weight than that of another witness, and you may give it such weight in considering your verdicts. In weighing the evidence, you may take into account matters of your common knowledge and your observations and experiences in the affairs of life. Ordinarily, witnesses may testify only about facts. However, witnesses with specialized knowledge in particular fields may give opinions in those fields. In determining the weight that you give to these opinions, you should consider the qualifications and the credibility of the expert, the facts upon which the opinions are based, and the reasons given for the opinion. Opinion evidence was received to help you reach a conclusion. However, you are not bound by any witness's opinion. It is your duty as jurists to scrutinize and weigh the testimony of the witnesses and to determine the effect of the evidence as a whole. You are the sole judges of the credibility, that is, the believability of the witnesses, and of the weight to be given to their testimony. In determining the credibility of each witness and the weight you give to the testimony of each, you should consider these factors: whether the witness is interested or disinterested in the outcome of this trial, conduct, appearance, and demeanor on the witness stand, the clarity or lack of clarity of the witness's recollections, the opportunity which the witness had to know and observe the matters and things about which testimony was given, the reasonableness of the witness's testimony, the witness's apparent intelligence, bias or prejudice, if any has been shown, possible motives to falsify, and all other facts and circumstances during the trial which tend either to support or to discredit the testimony, and then give the testimony of each witness the weight you believe it is entitled to receive. The defendant has testified in this case, and you should not discredit his testimony just because he is charged with a crime. Use the same factors to determine the credibility and weight of the defendant's testimony that you use to evaluate the testimony of other witnesses. There is no magical way for you to evaluate the testimony. Instead, you should use your common sense and your experience. In your everyday lives, you determine for yourselves the reliability of statements made to you by others, and you should do the same thing here. Evidence has been received that 2 of the witnesses in this trial have previously been convicted of crimes. This evidence was received solely because it bears upon their character for truthfulness. It must not be used for any other purpose. We're going to hear the closing. You know what? Does anybody want a break, even just a short one, or not? You want to go right into your discussion? Anybody need a break? Okay, we're going to hear the closing arguments of the attorneys now, and we follow the classical debate format in the court. That is that the proponent of a proposition is entitled to give the first and the last argument. So Mr. Binger will address you first on behalf of the state, then Mr. Richards for the defense, and then after his remarks, one of the attorneys for the state will be addressing you on behalf of the state in rebuttal, limited to rebuttal of things stated by Mr. Richards during his presentation. We're going to break, obviously. I'm not going to make you sit there for 5 hours unless you want to. So we'll break. I asked Mr. Binger while you were out of the room if he was comfortable with breaking his argument in parts, and he indicated he was. So at a time he thinks is appropriate, around noon, we'll take our lunch break and then pick up this afternoon. And after all of the arguments have been presented, I'll give you about 3 or 4 more minutes of instruction, and then we'll do our striking with the tumbler over there, and it'll be yours. So let me ask you.
Do you have the pointer? Sister's pointer.
Which one do you want?
The sister's pointer.
The sister's pointer? Okay. We'll take a vote right now. Supposing the case arguments are finished at 4:30, 5 o'clock, and we'll be working well to get there. How many would like to begin their deliberations tonight and stay until a later hour? Or how many would like to come back and start fresh in the morning? And the cutoff point would be, say we get finished by 4 and I give you the case. The latest I would let you go if you didn't want to stay late would probably be about 5 o'clock. So I don't know how much you'd get done, but you'd have the option to get started this today, or we just start fresh in the morning if we finish up anytime after 3:30 or 4 o'clock. So how many would want to continue on today? 1, 2, 3, 4, 5, 6, 7, 8. 8 out of, what do we got, 18? How many would rather come back fresh tomorrow? Knowing that some of you aren't coming back. Okay, and of course, as always, I'll make the final decision, but I certainly will try to follow your wishes. So, okay, with that, Mr. Binger, it's yours.
Thank you, Judge. Good morning, ladies and gentlemen. I want to assure you that everything that the judge just read to you, you'll get a copy of, so you'll have a chance to look it over yourself. You don't have to memorize everything he just told you. I think it's no surprise that this is a case that there's a lot of noise and a lot of static surrounding it. So what I'd like to do at the beginning is crystallize it in a nutshell for you and keep it as simple as possible. This is a case in which a 17-year-old teenager killed 2 unarmed men and severely wounded a third person with an AR-15 that did not belong to him. This isn't a situation where he was protecting his home or his family. He killed people after traveling here from Antioch, Illinois, and staying out after a citywide curfew.
Your Honor, I'm going to object. There's no curfew charge anymore. There's no gun charge.
Although he claimed
there's no charge, but and there has been some discussion about the lawfulness of the curfew, not in this case, but elsewhere. So there had been a curfew announced. That does not mean that it was technically lawfully a legal curfew, but there had been an announced curfew. So I'll leave it at that.
And it was a curfew that all the rest of us here in Kenosha were aware of. And I think most people, most reasonable people, obeyed. Although the defendant claimed to be protecting a business that he wasn't familiar with, the actual killings in this case had nothing to do with that. And he also spent the entire evening lying about the fact that he was an EMT. None of the things that I just told you are in doubt in this case. So when we think about the defendant, I'd like you to consider, as you think about this case, what his true motivations were. Was this a situation where he sincerely cared about CarSource, even though he'd never heard of it, never bought anything there, never worked there, and not even its owners were out there that night protecting it? Was he genuinely interested in helping people? He ran around with an AR-15 all night and lied about being an EMT. Does that suggest to you that he genuinely is there to help? He's not there for the same purpose as the protesters. So why was he there that night? When you think about these things, I think there are some things that we can all agree on. In America, it's hard these days. People are polarized and there's a lot of political issues back and forth. And the judge has made it clear this case is not about politics. There is common ground here. We have all agreed, and I asked you this 2 weeks ago today. Raise your hand if you agree life is more important than property. And all of you raised your hand. We also agree that no one person's life is more valuable than another. You don't get to kill someone simply because they're a drug dealer. You don't weigh a pastor's life over a teacher's life. You don't weigh a police officer's life over an engineer's life. All life is sacred. I think we can also agree that we shouldn't have 17-year-olds running around our streets with AR-15s, because this is exactly what happens. And finally, I want you to keep in mind that we've all read stories and heard about heroes that step in to stop an active shooter or to give their life to save others. In fact, many people in Wisconsin went out and got carrying concealed weapon permits just so that they could be there in case there was an active shooter and wanting to stop them. So when you consider this case, look for the truth. So many people look at this case and they see what they want to see. They have a preconceived notion and they tailor the facts to fit whatever they believe. And you all agreed to keep an open mind. You all told us you didn't have any of those preconceived notions. Now you've heard the evidence, and it's time to search for the truth. So consider, for example, whether or not it's heroic or honorable to provoke and shoot unarmed people. Consider whether it makes someone a hero when they lie about being an EMT. I think all of us are familiar with someone who does the sorts of things that the defendant has done. They enjoy the thrill of going around and telling people what to do without the courage or the honor to back it up, and without the legal authority to do so. And when you think about the defendant's behavior in this case, contrast it with Anthony Huber, a man who was there because he knew Jacob Blake, who carried his skateboard everywhere, and who rushed towards danger to save other people's lives. So when I talk to you here in my closing argument, I'm going to focus first on the murders that the defendant committed. Second, I'm going to address some background issues, give you some context, and talk about some of the things that I don't think are relevant to this case. And finally, I'm going to tie it all into the jury instructions that the judge just gave you. As prosecutors in this case, my colleague Jim Krause and I have tried to present you with all of the relevant evidence that we think you should consider in this case. And I told one of you in jury selection that at the end of this, you would be the expert. You would have all the information. You would be the one who would know all about this case and make that decision. And that's what we've tried to do. So let's go to August 25th, 2020. The defendant came from outside our community, carrying a gun that wasn't his, because he expected and anticipated violence that night. And he pretended to guard what turned out to be an empty building owned by people he'd never even met, while fraudulently claiming all night long to be an EMT. There were a lot of people out that night. Some people stayed home protecting their homes and their families. Others went to their businesses, boarded them up, and protected them. And a lot of those people had weapons. A lot of them had guns. There were other people who came along to protect Car Source or Ultimate Gas or other businesses. And many of them were armed with AR-15s, just like the defendant. In fact, you're going to see a video, and you've already seen it, of a clash between people with AR-15s at Ultimate Gas and other folks that are, I guess, protesters. And there's people getting in people's faces. There's yelling, there's shouting, there's even shoving. And yet, in this entire sequence of events, from the shooting of Jacob Blake on Sunday, August 23rd, 2020, all the way after that, everything this community went through, the only person who shot and killed anyone was the defendant. Yes, there was property damage. No one's here to defend that. No one's here to tell you it's okay to commit arson or looting. No one's here to tell you it's okay to be rioters. I'm not defending any of that. You know, because you've been told in the testimony, I'm prosecuting Joseph Ziminski for arson. That's not okay. But what you don't get to do is kill someone on the street for committing arson. So let's keep that in mind when we're talking about the people involved in this case. So let's begin with the provocation and the murder of Joseph Rosenbaum, because it's all captured on video. As the defendant and Mr. Rosenbaum arrive at the 63rd Street Car Source, Mr. Rosenbaum is ahead of the defendant. And as you see in the FBI video, when Mr. Rosenbaum starts to run, the defendant starts to run as well at the same time, as if he's pursuing him. Mr. Rosenbaum could not have possibly have known the defendant is behind him. There's no indication in this record that he knew the defendant was there. It's not an ambush. It's not a situation where he goes there and lays in wait for the defendant. The defendant arrives at that location and you hear him yell, "Friendly, friendly, friendly," because he's aware of the fact that the people that he's about to confront are hostile to him. And I'm going to show you in a moment the video in which the first thing he does when he arrives at that location is drops the fire extinguisher that he's holding in his left hand so he can raise the gun with his right and left hands and point it. This is when you hear someone, I think the testimony is Rosenbaum, it's not clear to me, but either way, yell, "Gun, gun, gun." And then Mr. Rosenbaum charges around to try and stop the defendant from pointing his gun or shooting anyone. So let's take a look at some of that video. This is Exhibit 73, the full drone video. And as we've pointed out to you before, and Jim will point out to you here in a second on the screen, when the defendant originally arrives at that scene, the first thing you see him do is drop the fire extinguisher and point his weapon at people. And then the chase occurs right after that. And you're going to see that entire sequence of events here on the full drone video. The defendant turns as he's being pursued and points the gun at Mr. Rosenbaum. And then as he enters the area between the parked cars, he slows and turns, and before Mr. Rosenbaum can even come close, he fires at him, shooting and knocking him to the ground. Now I'm going to show you the slowed down and zoomed in video of the defendant when he first gets there. And Mr. Krause is going to help me by directing your attention on the larger screen here to exactly where you will see the defendant. I'm going to replay it a few times so you can see quite clearly that the defendant sets the fire extinguisher on the ground with his left hand and then brings his left hand over to the gun and raises it and points. Guys, check the gun. Make sure it's empty. Under Wisconsin law, you're not allowed to run around and point your gun at people. This is the provocation. This is what starts this incident. The defendant rushes in and immediately points the gun. And as you'll see in a little bit, Mr. Rosenbaum doesn't take kindly to people pointing guns. I don't think anyone does. That's not unusual. No one wants to have the gun pointed at them, and no one wants to watch anyone else do this to someone else. We have the gun. It is in evidence as exhibit number 28. I'm having the detectives check it to make sure that it is safe. The defendant comes running in and drops the fire extinguisher on the ground like this. And then raises his left hand to the gun and points. This is what we see in the video. Him putting the fire extinguisher on the ground and then raising the gun.
Your Honor, I'm going to check. He's facing the wrong direction.
That's an argument.
Okay.
I'd like to actually have, well, I'll leave it alone.
So what you see in that video is his left arm reaching for the gun, holding it up. You can see it again on the video here. His left arm reaching up towards the gun. That is what provokes this entire incident. And one of the things to keep in mind is that when the defendant provokes the incident, he loses the right to self-defense. You cannot claim self-defense against a danger you create. That's critical right here. If you're the one who is threatening others, you lose the right to claim self-defense. Then we have the chase that occurs after that. And we have taken that drone video and we have slowed down portions of that chase for you. So what we have right here on the screen, this is Exhibit 84, and this is the middle portion of that incident. And you can see Mr. Rosenbaum chasing after the defendant, throwing that plastic bag, and then the defendant turns and points the gun back at Mr. Rosenbaum. And this is the moment in time when Mr. Rosenbaum essentially does sort of a little hop with both of his hands in the air. And the defendant has testified. He saw at that moment that there was nothing in the defendant's hand, or in Mr. Rosenbaum's hands. He was unarmed. There's the defendant turning and pointing the gun. Mr. Rosenbaum leaps, his hands out to the air, and then watch here at the end. This is where the shooting occurs. Mr. Rosenbaum is not even within arm's reach when the first shot occurs. I'll play that again. The defendant is pointing the gun at Mr. Rosenbaum. Mr. Rosenbaum raises his arms off to the side. The defendant approaches these cars and slows down, and then turns and shoots Mr. Rosenbaum. Finally, I'm going to play you Exhibit 86. This shows you the final part of that, zoomed in and slowed down. Here's the defendant running in between those parked cars, slowing down, and you can see just how close, or rather how far away, Mr. Rosenbaum was when the defendant shot him. You can see from this video that Mr. Rosenbaum is not even within arm's reach of the defendant when the first shot goes off. The defendant fires 4 shots in quick succession. And I'll come back to this in a moment, but you'll note during this entire sequence, it's the defendant who chooses where to go. He's the one who decides to run where he runs. And he slows down right as he gets to these parked cars. That's what allows Rosenbaum to get closer. We've seen this on the aerial footage from the FBI, and I want you to see that perspective as well. This is Exhibit 25. This is the annotated aerial footage. You see the defendant approach running in the same direction as Mr. Rosenbaum. This is where the pointing occurs in the direction of the Zeminskis. You can see Joshua Zeminski's right there on the screen. I'm going to put the cursor over where the Zeminskis are. They're right in there. The defendant is pointing his gun right here, and he's pointing it in the direction of the Zeminskis because they're standing next to that car. And then the chase occurs. Now, what's interesting to me is watch when the crowd starts to run. The crowd's already starting to run here even before the defendant has fired a shot. That's likely because they heard the first shot from Joshua Zeminski, and the crowd starts to run away. The defendant has testified that that shot from Mr. Zeminski had nothing to do with his decision to kill Joseph Rosenbaum, and I'll come back to that in a second. Finally, I'm going to show you this incident from the perspective of Drew Hernandez, because he is behind all of this, and then he comes upon Mr. Rosenbaum's body. Is that audio playing? Why is he having a phone? Is it coming? I'm sure why you're not hearing any audio on that. Is Brian around? He's not. All right. Can you text Brian, please? At any rate, for this purpose, at this point, the defendant has shot and killed Joseph Rosenbaum, and Mr. Rosenbaum is laying face down. That's where he falls. Richie McGinnis actually rolls him over after trying to stem the bleeding here. You can see in the foreground that plastic bag that Mr. Rosenbaum threw on the ground. I don't think there's any dispute. There was nothing harmful in that bag. It was a clear bag containing some clear items.
Objection. There is a dispute what's in that bag.
Then you can make that dispute in your argument.
It's argument, and you'll be allowed to respond.
You can see in this video the crowd is attempting to save Mr. Rosenbaum's life. So, we have shown you the defendant murdering Joseph Rosenbaum from 3 different angles. The drone footage, Drew Hernandez, and also the FBI video. The defendant admitted that during this entire incident, he knew that Joseph Rosenbaum was unarmed. I'm going to come back to this in a little while, but there's this alleged threat that Mr. Rosenbaum made earlier in the evening to kill the defendant. I will debunk that. That did not happen. It is the one fact in this case the defendant wants you to believe that there's no video of. And in fact, I have the video of the entire incident. I've played it for you and I'll show it to you again. There's no threat. There's also no evidence that Mr. Rosenbaum ever wanted the defendant's gun. He never said, I'm going to take your gun. He never said, I want your gun. There's no indication of that. Dr. Kelly has testified that the first shot that the defendant fired at Joseph Rosenbaum hit the victim in the right pelvis, fracturing it. Mr. Rosenbaum was incapacitated at that point. He is, whatever threat he might have posed, it's over. There is no further threat. He is falling to the ground, and the defendant doesn't stop after that first shot. He tracks Mr. Rosenbaum's body all the way down, firing 3 more shots. A second shot, which goes through Mr. Rosenbaum's hand, and then a third and fourth shot, one that grazes the right scalp and one that goes right into Mr. Rosenbaum's back. And that is the kill shot. That is the one that took Mr. Rosenbaum's life. There is no evidence that Mr. Rosenbaum was reaching for the defendant's gun. And after that first shot, there's no way Mr. Rosenbaum could have taken that gun even if he wanted to. He is already falling to the ground. He is helpless. He is vulnerable. And as I said, the kill shot is the one to the back. This is that wound. Dr. Kelly testified that the angle of this shot was from the left shoulder towards the center of the back, and the bullet continued on down towards the right lower back area, tearing through bodily organs and killing Mr. Rosenbaum. Here's a picture of the wound to the hand. There's been a lot of testimony about this wound. This is one in which the evidence suggests that Mr. Rosenbaum's hand was most likely turned in this position, palms outward with his thumb to the ground, when the bullet goes through the area in between his middle finger and his ring finger and penetrates the lower knuckle of the middle finger and the index finger before exiting. Dr. Kelly testified there's soot in that area, suggesting that the hand was close to the end of the defendant's barrel of the AR-15 at the time of that shot. The defense wants you to believe it's there because Mr. Rosenbaum is deliberately reaching for the gun. Well, that doesn't make any sense. First of all, this occurs after Mr. Rosenbaum has been shot in the hip and has got a fractured pelvis at that point. He is falling. He is not able to walk. He's probably not even able to control much of his movements at this point. When you're reaching for that gun, this is not the way you're going to do it. This is not going to be effective. I submit to you, ladies and gentlemen, to the extent Mr. Rosenbaum's hand ever got close to the end of the defendant's gun, it was completely inadvertent, not at all intentional. Now, we've heard a lot about the Zeminskis in this case, and I just want to carve them out of this case right now because it's a red herring. It has nothing to do with any of this. There's been some focus on that because I think the defense was hoping they could work this into their self-defense claim and make an argument that that first shot by Joshua Zeminski somehow made the defendant fear for his life. Unfortunately, the defendant wasn't on board with that because in his testimony, he told you that that shot had nothing to do with his thought process. It didn't affect him in any way. He said he didn't think the shot came from Joseph Rosenbaum. He knew Joseph Rosenbaum was unarmed, and he admitted to me, you can't kill Joseph Rosenbaum for something Joshua Zeminski did. So let's just carve Joshua Zeminski out of this case. I'll deal with him on his arson trial in January, but until then, it doesn't factor into any of the decisions the defendant made. And in fact, as you see on the FBI video, the Zeminskis continue walking straight on down the sidewalk. They don't pursue the defendant. They don't threaten the defendant in any way. Now, the defense wants you to think Joseph Rosenbaum was there to attack the defendant. We'll never know what Joseph Rosenbaum was thinking because the defendant killed him. So we're just guessing. But let's assume for a minute, yeah, Joseph Rosenbaum is chasing after the defendant because he wants to do some physical harm to him. He's an unarmed man. This is a bar fight. This is a fist fight. This is a fight that maybe many of you have been involved in. Two people, hand to hand, we're throwing punches, we're pushing, we're shoving, we're whatever. But what you don't do is you don't bring a gun to a fist fight. What the defendant wants you to believe is that because he's the one who brought the gun, he gets to kill. So I want you to contrast this, two different scenarios. One scenario where there's two guys who are throwing punches at one another like a bar fight. I think we'd all agree you can't kill someone. You can't punch the guy, knock him to the ground, and then get on him and strangle the life out of him. That's murder. So what's the difference here? The only difference is the defendant brought a gun. He brought his AR-15. That's why he's got to come up with this cockamamie theory that Joseph Rosenbaum was not only going to take the gun, but take it and then turn it on the defendant. And the defendant actually told you that he thought Joseph Rosenbaum was going to take that gun and not only kill him, but kill other people, which is really ironic considering the defendant is the one who killed people in this case and the only one. But putting that aside, they have to convince you that Joseph Rosenbaum was going to take that gun and use it on the defendant because they know you can't claim self-defense against an unarmed man like this. You lose the right to self-defense when you're the one who brought the gun, when you're the one creating the danger, when you're the one provoking other people. The defendant fired 4 shots at Joseph Rosenbaum and caused 5 wounds total. The first shot fractured Joseph Rosenbaum's pelvis. This causes him to be helpless. He is falling face first to the ground and he is vulnerable. The second shot went through his left hand, probably ricocheted off the ground and hit his lower left thigh. It's a flesh wound. I'm sure it hurt, but probably not all that serious. The third and fourth shots are as Mr. Rosenbaum has fallen almost completely to the ground. He's parallel to the ground. He is almost face first to the ground. The defendant fires a round into his upper back, which is the kill shot, and another round which grazes his right scalp. At this point, as you saw in that video, a crowd rushes to that body to try and save Joseph Rosenbaum. They're trying to put clothing on the wound to stop the bleeding. They're going to take him across the street to a hospital. KMH, Frederick South, is literally right across the street. And this crowd, except for the defendant, are all focused on trying to save this person's life. A person, by the way, they probably had never even met before. Because that's what most people do. Richie McGinnis testified. I rode with Rosenbaum in the back of that SUV. I told him we'd have a beer together when this was all done. Mr. Rosenbaum was unable to respond. The defendant decided to pull the trigger on his AR-15 4 times. That was his decision. And he is responsible for every bullet that comes out of that gun. He doesn't get a pass by pulling the trigger fast. He could have chosen to stop after the first shot, after the second shot, after the third shot, and assessed whether or not there was still a need to keep firing. But he went 4 times in 0.76 seconds. The defense has made a big point of this, how fast he fired, as if that somehow excuses him. Exactly the opposite, ladies and gentlemen. He controls how quickly he pulls the trigger. He is in control of that decision-making process. No one else made him do that. And this is indicative of someone who doesn't care about the consequences, doesn't care to stop and figure out, am I good? Do I need to stop? Or I'm just going to keep on going. And as I said, he tracks the body all the way to the ground with those second, third, and fourth shots. The only way that you could possibly justify the murder of Joseph Rosenbaum is if you believe that Joseph Rosenbaum was actually reaching for the defendant's gun, and that a reasonable person in the defendant's position with that AR-15 strapped tightly to his chest would think that Joseph Rosenbaum was even capable of taking that gun away as he's falling to the ground with a fractured right pelvis. And then, not only all that, you'd also have to believe that Joseph Rosenbaum was going to turn that gun around and use it to kill the defendant. You have to believe all of those things to justify the murder of Joseph Rosenbaum. That's why the defense is trying so desperately hard to convince you that Joseph Rosenbaum threatened to kill the defendant, which never happened. That's why they're trying so desperately hard to convince you that Joseph Rosenbaum was reaching for that gun. Because if he's not reaching for that gun and he's not going to use it to kill the defendant, it is not justified. There is no valid self-defense claim. One of the things the judge has instructed you is that when the defendant provokes this situation, he has to exhaust all reasonable means to avoid killing someone. Did he? He didn't have to shoot. He's the one who chose where to run. He chose to run in between those parked cars. He slows down as he gets there. The crowd's already running away. You know, the defense wants to make a point. There's a whole bunch of people over there who are doing stuff to cars, and the defendant had no escape route. The crowd's actually already running away at this point. They've heard the first gunshot from Joshua Zeminski, and they're already starting to scatter. But if you look on the video, there's a huge open space in that lot where the defendant could have circled back around, and he actually does circle back around after killing Rosenbaum, where he could have gotten away. He has to exhaust all reasonable means of escape before killing Mr. Rosenbaum. Your Honor, I do have some more video I want to play. I'm having a little bit of technical problems that I'd like to work on, so I think this would be a good time to pause if that's okay. Okay, thank you.
All right. Please don't talk about the case during the break. Read, watch, or listen to any account. And we will begin again at it's 1:45 to its own.
Did you say 12:45 or 1:45?
Oh, well, I thought we'd tell it leisurely. No, how about 12:45? Is that a better idea? Let's do that. Please don't talk about the case.
Well, there we have some of the state's closing argument. Many of us here at headquarters were surprised that this prosecutor was okay with having his arguments interrupted with the jury's lunch break. So when they come back, they'll hear the remainder of the state's closing argument. Then, of course, it's time for the defense closing arguments. Let's bring in our guest to see what he thinks about what we've seen so far from the state. Someone who has formerly served as a prosecutor. He's a trial attorney now in New York City. Imran Ansari is with us. Hi, Imran. Great to have you along today. What did you think so far, please?
Yeah, Julie, I think that Thomas Binger is doing a good job to start off. He is very methodical. He's calm, and his delivery has a way about it. You know, we saw a lot of fireworks during the course of this trial in that courtroom, a lot of heated exchange. But I would say that Thomas Binger, with his summation starting out, is opposite from that fireworks. It's calm, collected, and methodical. And he's using something that I used to always love to use as a prosecutor, a PowerPoint presentation, where he's sort of marshaling the evidence as it had come out to trial while weaving in the argument that supports the state's case. I think he's done a good job starting out, and obviously after this break, and I do agree, Julie, it's sort of you wouldn't necessarily want to have your flow interrupted like that. Perhaps it's a blessing now for Thomas Binger because he does have those tech issues he could work out through this break. That's true. That is the plus side, Imran. You're right about that. Speaking of interrupting the flow, how about right out of the gate, Thomas Binger talks about one of the charges that was dismissed. Count number 7 initially said that Cal Rittenhouse was accused of failing to comply with an order of the local government, the emergency management activity, meaning that curfew that was put into place. And it was kicked at the end of the state's case in chief, if you remember, because they didn't put in any evidence to that. And the defense was paying close attention and said, Judge, they haven't met their burden. The judge agreed. So that charge was gone. And when he referenced it, defense counsel rightfully stood up, made an objection. Boy, oh boy, I thought, did he have to go there? What did you think when you were watching that, please?
Right, Julie. So he had to sort of lay out the foundation of the facts there. He slipped those 2 references in, and of course, as you stated, the defense was up with an objection right away. And generally during summations, we as attorneys have sort of that professional courtesy, and we don't object unless it's really objectionable statements or conduct during the summations. We saw the defense object. Did he have to go there? Did he bring it in? I think it was just a narrative. It was sort of bringing to the fore in front of this jury some of the facts that now go to charges that are ultimately dismissed. But I think that we now see him hitting his stride during this summation. And I think he's doing, again, I think he started off with a good start, and we'll see how it develops.
Right. If you had to give him one quick piece of advice for the second half of the close, what more would you like to see him do?
Well, I want to see a little more, I would say, emotion. I think it's his style to be methodical. And as a prosecutor, you tend to be methodical. You are representing the government, the state, and you are bringing forward charges on behalf of not a client, but the state. So I think if we see more passion, and I think we may from Thomas Finger as it goes forward, that's what I want.
Imran Ansari, thank you so much. You're going to stay with us as we're heading into the next hour. We're going to squeeze in a quick break. Lots more still ahead here on Court TV Live, including those motions for a mistrial in the case against the 3 men accused of murdering Ahmaud Arbery. We'll be right back. Big day here in Kenosha, Wisconsin, as we are watching the closing arguments in the trial of Kyle Rittenhouse. Thank you for being here, watching along on Court TV. Of course, we're in Brunswick, Georgia as well. Lots to tell you about that case. But first, we want to get the details live from Kenosha. We want to bring in Court TV anchor Ted Rowlands, who is standing by, watching all of the big developments today. Ted, good afternoon. It is great to see you. I know, before things got underway with the arguments, there was so much that the judge was tackling, and then we saw that dismissal. Let's start there with the gun charge. Walk us through what happened there, if you would, kindly.
Yeah, that count 6 was ultimately dismissed after some back and forth between the parties. At the end of the day, Judge Schrader ruled that after the defense admitted that the evidence that has been brought into trial and that they acknowledged that this gun in itself was not illegal, that was out. And it was after a sort of beleaguered back and forth, it was a quick Judge Schrader classic, then it's out. So that changed it for the jury. Now down to 5 counts, and they're just hearing the beginning of what we expect to be an extensive closing argument given by Thomas Banger.
Right, Ted. And then what other highlights, besides that gun charge, which it makes sense when we heard the judge explaining about the length of it, it just is not legally a dangerous weapon under the statute in Wisconsin, so it has to go. What else from, this morning really jumped out at you as you were watching along, please?
Well, just that there is so much at stake here, and Judge Schrader obviously knows it. They were literally going over the language back and forth for jury instruction. We've seen versions of this happening, but this was to another level, and he acknowledged that on the record, saying that we want to get this right if we can. That one mistake during this process could, as he said, bring this whole thing down, and it'll fall like a house of cards. So you can feel the tension here. I'm outside the courthouse. There's a group of protesters outside the courthouse here. The National Guard has been put on alert. They're staging just outside the area here near the county courthouse. And if need be, they'll be here. The country is watching this verdict, and the judge knows it. The attorneys knows it. And I think that's why so much back and forth took place even before the closings began.
Oh, definitely, Ted. We know Kyle Rittenhouse's mother, Wendy, has been in the courtroom every day watching closely, and she's also been doing some media interviews. What's the latest on what she's been saying, please?
Yeah, she was on Fox the other day, and then over the weekend, she talked with Gabe Gutierrez at NBC News, and she is articulating the same sort of theme, and that is that she's proud of her son. She doesn't think he did anything wrong, but she did also admit that she's a bit frightened about what lies ahead. Take a listen.
A lot of people shouldn't have been there, and he brought that gun for protection. And to this day, if he didn't have that gun, my son would have been dead.
Are you anticipating, looking forward to, dreading the verdict? How would you describe what your feelings are going into this one?
I'm scared.
Scared. That's Wendy Rittenhouse over the weekend talking to NBC, and that makes sense. Everybody who's in this position is scared right before a jury is about to decide your fate. And we're seeing it play out this morning. And one of the things I noticed, Kyle Rittenhouse was back to his yawning. He, whether that's a nervous reaction or if he didn't get enough sleep, either way would make perfect sense for this young man as he waits to see what this jury decides.
Yeah, the world is watching. We know that. Court TV anchor Ted Rowlands, thank you so much for that update. We'll check in with you later. All right, I want to bring in our guests now. We have on the program standing by still in New York City, trial attorney Imran Ansari. He's also formerly served as a prosecuting attorney, and just joining us in Denver, Colorado, former district attorney and trial advocacy professor George Brockler. Great to have you both. George, I want to start with you, if I may, please. What did you think of the state's close so far?
Missed opportunities at the beginning. Listen, to start off with an upbeat sort of, thank you, Judge. Good morning, ladies and gentlemen. Now, that may be proper etiquette in some places, but for this case, it is let's get it on right now. And what I think the prosecutor missed was he buried his lead. And it took about 10 minutes for him to get to saying, you don't get to claim self-defense if you're the one that creates the situation, if you're the provocateur. Those should have been the first words out of his mouth. This isn't a whodunit. This isn't even really what happened. This is a question of a guy who's entered self-defense, which means he admits to what he did. Cut right to the chase and make sure that they know at every turn. And I'd repeat it a million times. You don't get to claim self-defense if you're the one that created the situation. You can't use lethal force to protect yourself from something you created. He needed to do that, and he is building up momentum. I agree with that. And your point that you brought up earlier, there's no chance I would have ever agreed to having my opening statement split up, even for a technological advantage. I would have said, Judge, I'd rather they take an early lunch and then come back and let me do my thing.
Exactly. I'm glad to hear you say that, George. I thought the same thing. We were all just going, what? What? Why would you want that? But then again, he does have that very calm way about him. I thought maybe today we would see some passion and fire, and he's still behind that podium, Imran. What do you think of that in terms of the style of his delivery, and kind of piggybacking on what George was just saying about how Thomas Binger approached this?
Yeah, Julie, listen, I've seen styles in attorneys and prosecutors who come in with a lot of passion, really getting before the jury the outrage of whatever crime they are prosecuting. I was a prosecutor like that, and when I go to court now, still, I tend to be on the more passionate side. But to Thomas Binger's credit, I have had colleagues and friends who have a total different style, who are more calm, more, almost educating the jury, going through points as Thomas Binger is now doing, and really delivering a message of their case, of why they've proven their case in a calm, sort of professorial sort of a manner. And I've seen that used to great success. You sort of, as long as you keep the attention of the jury as you go through that and keep them engaged, I've seen that style also be very successful. And I think Thomas Binger, I actually think he's doing a decent job going forward. And maybe he sort of buried the lead there, but I am expecting, or at least hoping, in terms of a style of advocacy, he does repeat that as we go through his summation, and keeps bringing the jury back to the point that this was not justified if he is going to prove his case beyond a reasonable doubt.
Imran, thanks. George, tell me what you thought about the moment where Thomas Binger left the podium and picked up the AR-15 and raised it up and pointed it. What did you think of that move, please?
Yeah, it's dramatic. And I suppose I've picked up weapons during murder cases as well, probably never with that kind of flair. But I get the point he's trying to make. And I think that what we're hearing, and I appreciate this too, is he doesn't have a dramatic presentation with his voice. And so he has to make up for it in different ways. And perhaps presenting that firearm in that manner was a way to bring the gravity to the jury right there about what was used to kill these two men. And again, I just can't emphasize enough how important it is that he continue to hammer home that that guy at that table took 2 lives. And he had no justification to do it. Just to repeat that and continue to do this through his presentation. And maybe we're getting there. I hope we're getting there. And that maybe the gun is his effort at drama. I don't know.
Mm-hmm. Imran, what do you think about that? And I know it was hard to see. I was asking, as I was sitting here watching it, I was like, oh my gosh, I hope our camera operator can go wide on the shot and show it more. But we couldn't because of where the jury is seated. Remember, they're right next to the state's table. So they would be in that direction. He kind of looked like it went catty corner, maybe between the jury and the gallery. But either way, what did you think of the pointing of it? Smart move or not?
Well, Julie, I think, yes, it was Binger's attempt at a dramatic moment. When you have a murder weapon at trial, it's good to show the jury. You use it during a demonstrative sort of exercise during your summation. I think it was pretty quick. Maybe it was just the camera, as you mentioned, the camera angle we got. Maybe he could have used it to more effect. But you want to remind the jury of the murder weapon, of the tool that was used to take lives here, 2 lives, and injured another. So Thomas Binger perhaps was using it, and perhaps we'll see it again as he goes through his summation, as he goes through the Huber shooting and the Grosskreutz shooting. We may see this firearm again.
Mm-hmm, right. Yeah, I'm all for picking up The rifle, displaying him, and I would have it front and center right on counsel table if I was one of the prosecutors, hold it in my hands as much as possible, but I wouldn't have gone so far as to point it. That's just me. I'm not trying the case, though. It's great to have you both on the show. Imran Ansari, George Brockler, thank you so much. We're going to leave it there for now. We're going to take a break. When we come back, we're going to take you to Brunswick, Georgia, as the 3 men accused of murdering Ahmaud Arbery are all moving for a mistrial. And it has to do with someone very famous, a famous Black reverend who's in the gallery today. We'll explain when Court TV continues. Welcome back to Court TV Live, your front row seat to justice. I'm Julie Grant. We want to get you caught up on what's been happening in Brunswick, Georgia, as we've been seeing what's been happening in Kenosha. I want to bring in legal correspondent Julia Janae. She's been in the courtroom for the trial of the 3 men accused of murdering Ahmaud Arbery. And wow, oh wow, has there been lots of action there today. Julia, tell us what we missed, please.
Julie, there has been so much that has happened just before lunch broke for the day. They are now starting up again, but one of the major things was the presence of civil rights icon Jesse Jackson in the courtroom today. We saw him walking in. We knew this would likely bring up some issues inside of the courtroom because of one of the defense attorneys, Kevin Goff, for William Rodney Bryan, his objections to, quote, any more Black pastors being inside the courtroom. I was inside the courtroom sitting in front of the Reverend Jesse Jackson, who was seated between Wanda Cooper Jones and Marcus Arbery, both of the parents of Ahmaud Arbery. And we thought that this was going to be really the fireworks inside the courtroom. Kevin Goff did raise a motion during the morning break, objecting to his presence, saying that he doesn't know how many pastors are going to be brought in, and this is influencing the jury in a negative way. And the body language from people in the courtroom, including the other defense attorneys, was, why are you bringing this up again? Please don't do this. I could even see the wife and mother of two of the defendants, Lee McMichael, shaking her head while this was happening, putting her hands up to her brow. But that all changed as far as that distance from Goff and this motion after an emotional reaction in the courtroom. There was a spark of life witness who took the stand, who showed a picture of Ahmaud Arbery, and Wanda Cooper Jones could not hold back her tears. You could hear the weeping, and the jury noticed this. After that, the judge quickly asked them to leave the courtroom so that the commotion could die down. And then we had a motion for a mistrial from all three defendants, with those other two who aren't typically the ones who raise these motions, Julie, the attorneys for Gregory and Travis McMichael. They said they were constrained to join because this was such a unique moment inside of the courtroom.
And Julia, what exactly did they identify as the basis, the legal basis for motioning the court to declare a mistrial?
Because of the impact that this could have had on the jury, Laura Hogue said that she noticed several of the female jurors, I did as well, looking at Wanda Cooper Jones when she was trying to hold back those tears. It seemed she was just really overcome seeing that image of her son inside of court. And she said that they then looked not only at the gallery, but then connected eyes with her, being this woman attorney sitting at the seat. And she said, just as a human being, as a person, you could see that this is impacting them and that emotion should not be in the court. The Hogues also said that it is becoming more clear that they can't get an impartial jury in Glenn County, and mentioned a change of venue, something that the attorneys for Travis McMichael, Bob Rubin and Jason Sheffield, they say they don't believe that there's a need for a change of venue, or rather Kevin Goff said he didn't believe that there was a need for a change of venue. But Jason Sheffield said that you can't ignore the impression that not only the image of Wanda Cooper Jones crying in court had, but also Reverend Jesse Jackson sitting there next to her. He mentioned that his own mother for years had an autographed picture of Jackson hanging on the wall, and the enormity that his presence brings, that moment was so unique that it's something that he felt created a situation where they can't get a fair trial for their clients.
And did the judge rule yet on that, Julia?
The judge did rule, and he started by saying that emotions are expected. They are a natural part of the court, and the court has taken those steps to limit what this jury is exposed to. But he said it's ultimately up to the discretion of the court, that he noticed he heard someone sobbing and he quickly asked the jury to step out, and that was the cure for this. But he did take all of this into consideration. He also mentioned that Kevin Goff, some of the statements that he has been making on the record in the courtroom, particularly objecting to Black pastors, but also saying, what if we brought in people dressed as Colonel Sanders wearing white masks, that those kind of reprehensible remarks could be creating the kind of commotion outside of the courtroom that Goff has also objected to inside of the courtroom.
Oh my. Wow. What a morning and afternoon it's been there. Julia, I know you are the pool reporter today. I'll let you go and get back into the courtroom. Thank you so much for all of that information. What we're going to do is go back live. Now, we understand that testimony has just gotten back underway. The next state witness is a woman named Jessie Worley, and she is a fingerprint analyst.
And any of the known prints that are on the records that we have for comparison. During the comparison, we're looking for similarity or differences. It just depends. Not every comparison will result in a match or an identification. So you may see more differences than you see similarities. But as we start to make the decision in our mind in what the result of that comparison is, that prompts the beginning of our evaluation phase, which is really the decision-making part of the process. In the ACV methodology the way we use it at GBI, we can make an identification, which means that we've determined that the latent print and the set of known records we're comparing it to came from the same person. We can have an exclusion, which would mean that the latent print and the known prints were made by different sources or different persons. Inconclusive would be that there's just not enough detail to say definitively it either is or isn't this person. Or it can also be that we need a better set of records. Maybe the one set we were given may not have been clear enough in a specific area, so we may say that we need new records for comparison. And then lastly, we also use a conclusion that's called was not identified, or no identification was made, which is, it's kind of like it's not an identification, and we're confident that the latent print is not from a specific source, but we haven't compared it enough to say that it's definitely an exclusion. Exclusion decisions tend to, in some instances, be harder to make. When you're doing a comparison as an examiner and you start to feel like you're making an identification because you're seeing and observing features in the same arrangement and you're seeing the similarity, it becomes very easy to say when you've reached an identification because you have like proof positive, this feature is this feature, this one is this one, and everything lines up and you can see it. When you have an exclusion, sometimes depending on the area, if you're looking for like within a large area of the palm, there's a lot of area to search and you have to exhaust all the available features in relevant area of the skin before you can confidently say that you have an exclusion. So sometimes exclusion decisions are harder to reach than an identification. And so what we have adopted in our policy is that I know it's not an identification, but I haven't fully excluded this particular person yet. And that we report as, excuse me, we report that as an identification has not been made.
Now, I want to turn your attention to DOFS case number 2020-6001183. Okay. Who are the subjects involved under that case number?
According to the report that I have, the subjects that were listed on the evidence submission forms were listed as Gregory Johns McMichael, Travis James McMichael, and William Bryan.
Okay. And who's listed there as the victim?
The victim is listed from the evidence submission forms as Ahmaud Arbery.
Okay. So I want to turn your attention to the work that you did in this case.
Yes.
Okay. What items did you use to do your comparison in this case?
The latent prints that I was asked to examine were on evidence that was labeled as item 21 in the GBI Crime Lab information system. I itemized them to be 21A, 21B, 21C, and 21D. So those were all latent lift cards that were submitted.
Okay.
And then I was given known finger and palm print cards bearing the name Amy Eileen Elrod and William Roderick Bryan Jr.
Okay. And did you also use known prints of Ahmaud Arbery?
Yes, they appear as item 24.
Okay. All right. If I can just have Mr. Camarillo help me out with this here. Thank you.
Permission to group? Yeah, that's fine. And y'all can move around if you need to move around.
And Ms. Worley, are you able to see what's there? What's pictured? If you need to step down, you can. Just make sure you're speaking loud enough for the court reporter, okay?
Okay.
Okay. Are you able to see this?
Yes, I think so. Okay.
Okay, please be careful. Please. Okay, so do you see what I have here? AE known prints. If you need to, you can.
Yes.
Okay, so Amy Elrod known prints, you said you received those, right?
Yes, those are marked as item 20A on my report.
And did you also utilize William Bryan's known prints?
Yes.
And also Ahmaud Arbery's known prints?
Yes.
Okay. And submitted latent lists, we talked about those, right?
Yes.
And did you say they were labeled 21A, 21B, 21C, and 21D?
Yes, ma'am.
Okay, so if we can just start, I guess, in reverse chronological order with D, 21D. What did you determine about 21D? If I could just get the cap off of my marker.
For 21D, after I did the initial visual examination for latent prints on that item, I determined that that item was negative. There was not any friction ridge detail that could be used for comparison.
Okay, so 21D negative for latent prints, right?
Yes.
Okay, go on to 21C. What did you determine?
So the results of the visual examination for 21C was positive. There was friction ridge detail present, but upon analysis, I determined it to be unsuitable for comparison.
Okay, so positive for latent prints, but still
unsuitable.
Unsuitable
Yes, ma'am.
for comparison. Okay, so that leaves us with 21A and 21B. Looking at those lifts for 21A and 21B, what, if anything, did you see in those?
So on both item 21A and 21B, my visual examination result is that these items were positive for latent prints. I also noted that they appeared to be duplicate lifts of the same latent print.
Okay, so we have essentially A and B are the same print.
Yes.
Okay.
And that's something that from experience in the way latent prints work, you can't ever create the same impression twice. They're always going to have different shape, different amount of distortion and movement because of the pliability and the way the hand is built anatomically, that you can't ever create the same thing twice. So when we see lift cards that are the same in most aspects, it's likely that they are duplicate lifts where the impression is powdered and then a piece of tape is used to lift it, and then a piece of tape is used to lift it a second time. And then both lifts were submitted.
Okay, so before we go further on A and B, I just want to double back to D. So were you able to compare anything to D?
No, it was negative.
Okay. Were you able to compare anything to C?
No, because it was determined to be not suitable or unsuitable.
Okay, so no comparisons here.
No, correct.
Okay, so back to A and B, positive for latent prints, but the same.
Yes.
Did you use one over the other for comparison purposes?
Yes.
Which one did you use?
I used 21A because it appeared to be the first lift. The development was a little darker on the card, is a little clearer than what was visible in B.
Now, go ahead and just tell the jurors your findings for 21A and the process that you used, of course.
So I completed an analysis of the latent print that was on 21A. I determined that the print appeared to be from the right palm of an individual and that there was sufficient detail present to determine it to be suitable for comparison. At that point, I began the comparison process by comparing the latent print to the palm print cards for Amy Eileen Elrod and William Roderick Bryan Jr. And my conclusion for both of those comparisons is that no identification was made.
Okay. So for Amy Elrod and William Bryan, you said no identification?
Yes, ma'am.
Okay. All right. What did you do next, if anything?
At that point, I compared the latent print from 21A, which again is that palm print, to the palm print cards that bearing the name Ahmaud Marquez Arbery, and was able to make an identification to that set of records.
Okay. So identified to Ahmaud Arbery.
Yes.
Okay. So positive ID. Okay. And did you testify that that was the right palm print?
I did, yes.
So from his right hand?
Yes.
Okay. Were you able to tell where on his right palm that print came from?
Yes.
Okay. So may I approach, Your Honor? Yes. Okay. Actually, can you step down, please, Ms. Worley? Okay. So I'm going to show you my hand and right hand. And if you can just show, and if you can come so we can just go this way.
All right, please pull up a second. Yeah, go ahead. You do have your back to the part.
Oh, I'm sorry. I'll do this.
If everybody could speak up because you're off mic.
Of course, Judge. Thank you. We will.
I'm just going to flip to the image that I had of the lift card.
Okay. And my hand is cold. I'm sorry.
Okay. So
Okay.
the shape of the impression that was made, or the shape that appears on the lift card, is indicative of being from the edge of the palm. So this area here, it's commonly referred to as a writer's palm, because when you're writing and your hand moves across the page, it's usually that portion of the palm that rests on the paper.
Okay.
And so it was very similar to the shape of the palm print that was on the lift card, 21A, and then subsequently as well, 21B.
Okay, so 1 second before you sit. So if I'm holding this marker in my hand, are we talking about like that side that's resting here?
Yes, and then sometimes it varies whether it's very, straight up and down, or if it's angled in a little bit more to get more of the center portion of the palm. But that's still typically referred to as the writer's palm when it's that outer edge of the palm.
Okay, all right, you can have a seat. Thank you so much.
We lost some lights.
We can move it. We can move it, yeah. We can move it. I think we're gonna move this.
Maybe we should just not touch anything.
So, Ms. Worley, what, if anything, in looking at the lift, what, if anything, did you observe as it relates to the presence or absence of moisture?
In this particular impression, there did appear to be some areas that looked like they might have been wet or had an additional amount of moisture than other areas within the same impression. In my training and my experience, one of the things that we are taught to look for as an examiner is what kind of differences may still be present even when an identification is made. As I testified already, you can never create the same impression twice. So even when we have an identification, the latent print is never going to look exactly like the known print. I know sometimes on TV, they show them up on screens and they overlay them and ta-da, they match perfectly. But that's not really how latent print comparison works. There's always going to be inherent movement and distortion within any impression that sometimes may be recorded in known prints. Sometimes known prints are well recorded and they're free from as much distortion as possible. But one of the things that we have to evaluate in making an identification decision is, are we seeing differences that are due to moisture or surface or development issues? Or are we seeing differences that are inherent to them being from different sources? And we have to use tolerance where appropriate in making that decision. In this instance, there were areas of the impression that do appear to be wet. The ridges do have a different appearance, and the powder does adhere or react differently to more wet areas of the impression. And so that was one of the observations that I did make in this case, but it wasn't so significant that it overreached the tolerance that I can use in making an identification decision.
Okay, so it didn't affect your evaluation in terms of the identification to Mr. Arbery?
No, but it does make a difference in explaining why, if it were to be put up for anyone to see, the latent print does not look exactly like the known prints. And one of the reasons for that is there is moisture present.
Okay. And in doing your comparison, did you follow valid scientific procedure and methods accepted in your field?
Yes, I did.
Okay. And are those methods reliable?
Yes. I believe actually in going through the ACV method, I left off the V portion. The last part of ACV is the verification. Our policy at GBI requires that if all of our decisions are verified by a second examiner, with the exception of the no identification decision and some of our inconclusives, but my suitability decisions for A, B, and C, those were all verified by a second examiner, and then my identification.
All right, as we are at the bottom of the hour, we're going to squeeze in a break. And remember, the jury's going to be back in just about 15, 20 minutes from now in Kenosha, Wisconsin as well. And we're going to take you there live for more of the closing arguments in the Kyle Rittenhouse case. Thank you for watching Court TV. Thanks for staying with us here on Court TV Live. I'm Julie Grant. We want to go back together to Brunswick, Georgia now and hear more testimony from the state's fingerprint analyst still on the stand.
No question, John.
No question, John. Any redirect?
No, Your Honor.
Thank you. You may step down.
Thank you.
And you are excused, but subject to recall. Thank you. Is the state ready with its next witness?
Yes, Your Honor. At this time, the state's going to call Special Agent Lawrence Kelly.
Swear to tell the truth, the whole truth, and nothing but the truth.
I do.
Go ahead, have a seat.
All right, please state your name and spell it for our court reporter, please.
My name is Lawrence Kelly. That's LAWRENCE KELLY.
And how are you currently employed?
I'm a special agent with the GBI, just the Georgia Bureau of Investigation.
All right, and what is the Georgia Bureau of Investigation?
We are a state law enforcement agency. We're the investigative arm of the state government. We, when requested to do so, can assist local agencies with investigations, or we can initiate certain investigations on our own involving certain specific violations of Georgia law.
All right, so you're a special agent. What does that mean?
It means I'm a Georgia Post Council certified law enforcement officer. I have the powers of arrest throughout the state. I have a specialized training in various forms of investigative practices, interviewing, interrogation, certain specialized training in examining cellular telephones and cellular telephone records and elder abuse investigations and general just investigations.
All right, so you got the normal training that the GBI provides all special agents, is that right?
Yes, ma'am.
Okay, but you have some special technical expertise.
I do.
All right, tell the jury about your special technical expertise.
I have two specialties. One is not really pertinent to this case. I'm a elder abuse or at-risk adult crime specialist. The other one, I am a technical specialist in the gathering and use of data from cellular telephones and social media records. I have specific training in to download and extract data from cellular telephones, to obtain records from various providers, and to analyze those records.
Right. So Be fair to say that sometimes you're the tech guy who gets called out by other fellow agents?
Yes, ma'am, happens quite frequently.
All right. So, directing your attention specifically to May 6th of 2020, did you become involved in the homicide investigation for Mr. Ahmaud Arbery?
I did.
All right. How did that come to you?
I was called. I was not involved in the early stages. I was called by ASAC, Assistant Special Agent in Charge, Richard Dial, who was my direct supervisor, and he told me to report the next morning to assist in some technical matters involving the Arbery investigation.
All right. So he was the one who was in charge of the investigation.
He was, yes, ma'am.
All right. So Richard Dial calls you up, and at this time, did you then submit some video files to another arm of your agency?
I did. When I arrived the following morning, I submitted 2 video files that I had received from ASAC Dial that were videos, 2 videos. One was about a little over probably a minute and almost a little shy of 2 minutes long. The other one was a truncated version of that video to Matthew Heath, who is a digital forensic investigator with our Child Exploitation and Computer Crimes Unit in Decatur.
Okay, so we'll go ahead and take that piece by piece. When it comes to the Georgia Bureau of Investigation, that's a statewide agency.
We are.
So where is your office?
My office is in Kingsland, Georgia.
All right. And Matthew Heath, where is he out of?
His office is at our headquarters in Decatur, or at the time was at our headquarters in Decatur.
Decatur, and that is close to what town?
Atlanta.
Okay. So now he was in a different unit, you said.
Yes, ma'am. The Child Exploitation and Computer Crimes Unit. GBI has 2 computer-based units, the CIAT, which is the unit I just mentioned, and the Georgia Cybercrime Center in Augusta.
Gotcha. So he is a digital forensic investigator?
Yes, ma'am.
All right. So how is his job duty different than your job duties?
He's not a sworn agent. We do some of the same things. As a cell phone expert, I can download and extract data from cell phones and pretty much cell phones by themselves. He can do that for cell phones, computers, other devices. He also has the ability to do other technical things such as enhancing video files or reviewing video files for information.
Okay. So you sent him a 1 minute and 43-second video. Is that the video of the homicide of Ahmaud Arbery?
It is.
All right. And the shortened version of it, that was the duplicate?
Yes, ma'am. It was a truncated version originally created. I viewed the metadata. It was originally created approximately 30 some odd minutes after the first video. And it's just by truncated, I mean, it's just a cut portion. It's like a 36-second portion of the original full video.
All right. So did you also send him surveillance video from 219 Satilla Drive?
I did.
Did you also send him 5 surveillance videos from the interior of 220 Satilla Drive?
I did.
And were those the ones dated February 23rd of 2020?
Yes, ma'am.
Did you also send him 47 surveillance videos from 224 Satilla Drive?
Yes, ma'am.
All right. Now,
it is that time where we want to squeeze in a break because we know pretty soon we're going to be shifting gears back to Kenosha, Wisconsin. The state's closing arguments broken up with a lunch break in between, and the prosecutor was okay with that. Stay right here. This is Court TV Live, your front row seat to justice.
What do you think the future looks like?
From Newsy, renowned journalists and filmmakers, comes a celebration of storytelling.
Are we in a killer robots arms race right now?
When the suspect admits to it.
I'm not going to argue the law with you.
New features every week. Newsy Docs presents Sunday nights at 9/8 Central, only on Newsy.
Newsy Tonight is changing the conversation.
Incredible footage coming in live right now.
Primetime news focused on facts.
We're not really as divided as it may seem. Let's break down our latest Newsy poll.
Newsy Tonight, weeknights at 8, only on Newsy.
What if the news was different and covered more than one side of the story?
Justice wasn't served.
so you can make up your own mind.
I love this so much.
Introducing the new point of view. Yours. Newsy. Watch free. 24-hour news.
This is true crime all the time.
We continue our gavel-to-gavel coverage.
We are live in courtrooms across the country.
This is what I love to do.
This is CourtTv.
What a day it has been as we continue our gavel-to-gavel coverage.
Is there reasonable doubt? We'll find out.
Welcome back to CourtTv Live.
Your front row seat to justice.
What if there was a show that connected the dots by offering different perspectives? What if primetime news skipped the talking points and focused on the issues y'all might want to hear?
People around the world have been hosting their own virtual weddings.
No matter how weird. Join me, Christian Bryant, for a different kind of nightly news show. In the Loop, weeknights at 9, 8 Central, only on Newsy. What if primetime news told it like it is by highlighting different perspectives? Join me, Christian Bryant, for a different kind of nightly news show. In the Loop, weeknights at 9, 8 Central, only on Newsy.
All right, we're watching the courtroom closely in Kenosha, Wisconsin. No action just yet. The jury's still on their lunch break, so we're going to take you back to Brunswick, Georgia, where Special Agent Lawrence Kelly is on the stand with the Georgia Bureau of Investigation. Let's watch.
Now, I'm going to stop this right here. With regard to the difference between 191 and 192, 191 was slower?
Yes, ma'am. 191 is a half speed from the original, and these are from the 36-second truncated video. These are half speed.
All right, and then the high contrast, that is at which speed?
Looks to be at full speed.
Full speed. All right. And so when we get to approximately here, which appears to be at about 10 seconds. Describe this image as compared to the half-speed image. I guess, is it brighter or darker?
It's brighter. As you can see, the road on this one is kind of washed out, and the sun, you know, instead of seeing the blue sky in the south, you just see white where the light has washed out the pale blue in the sky.
All right, and the intent behind this is so you can see what?
see things that are maybe might be obscured by shadow in the original video.
All right, so when we look at this right here, I'm gonna focus your attention right in here, okay? Are we able to actually see what takes place here? I'm gonna hit play. What happened right there?
It appeared that the person known to me as Mr. Travis McMichael raised his hands in this kind of motion.
Did you see what he had in his hands at that time?
He had something in his hands. I couldn't see directly exactly what it was at that point. I can infer what it was from context from later, but.
And in context from later, what does he have?
A shotgun.
Your Honor, I'm going to object to the witness describing what is obviously in the video. I don't understand why the witness needs to say there are trees in the video, there's a road in the video, that Travis McMichael's holding a shotgun.
What we're going to do now is leave Brunswick, Georgia. We have our crew there that's going to stay there now. Our Julia Janae is the pool reporter today. She'll be in the courtroom. We'll bring you updates as we can. We're going to shift gears and go back to Kenosha, Wisconsin. Everyone in the courtroom is on their feet as the jury has been summoned to come back into the jury box. And you see the prosecutor there standing near the podium, getting ready to deliver the remainder of his closing arguments.
Let's continue, Mr. Hinger.
Thank you, Judge. Good afternoon, ladies and gentlemen. I'm going to continue on. I hope your full stomachs won't distract you too much from the presentation here. So I had been talking about the murder of Joseph Rosenbaum. And as you can tell, I'm trying to go in chronological order. I'm trying to go through these events in a way that makes the most sense. So count one of the information is with regard to Joseph Rosenbaum. The second count of the information pertains to Richie McGinnis, who you heard testify. He testified that he was in the line of fire behind Joseph Rosenbaum as the defendant fires 4 rounds with his AR-15, which is loaded with full metal jacket ammunition. And I'll talk a little bit more about that type of ammunition in a little bit. But you've heard testimony that it's the type of ammunition that is capable of going through body armor. It is capable of going through a squad car. It is designed to go through the target and continue flying on for up to 550 yards. Richard McGinnis testified that when those shots went off, he thought he had been hit. He thought his life was in danger. One of the rules that I think most people who are familiar with firearms knows is always check your background, meaning know what's around your target and know what's behind your target. This is true when you're hunting, it's true when you're target shooting, and obviously it's true when you've got an AR-15 in downtown Kenosha in the middle of protests with houses and people nearby. But there's no indication the defendant cared one bit about his background, cared one bit about where those bullets were going to go. And as I said, he put Richie McGinnis in danger. Richie McGinnis, after this incident you've seen on the videos, goes to try and help Joseph Rosenbaum and has his own video shows. When he first gets there, he finds Mr. Rosenbaum's body face down on the ground. And I'm going to play this exhibit 15 for you.
You okay? Just don't move, man. Don't move. All right, can I flip you over real quick? I'm gonna flip you over real quick, bro. Flip over real quick. Just gotta get pressure on this, dude. Where's it at? Where is it? I mean, turn around. Where's it at, dude?
You want to talk about medics? You want to talk about people who care? You want to talk about people who are there trying to help? You just heard them and you just saw them. People who didn't know Joseph Rosenbaum. They just knew somebody needed help. And while that's going on, the defendant flees, callously disregarding the body of the man that he just shot and killed. And as he's running off, he's lying to the crowd about what just happened. This is exhibit number 12.
So there was just like 6 shots. It went off.
The defendant says he pulled a gun. That statement, he pulled a gun, was a lie. It's not true. The defendant knew it wasn't true. He's lying to the crowd as he's running away. Joseph Rosenbaum didn't have a gun. The defendant knew he didn't have a gun. The defendant is lying to save his own skin instead of going and trying to help the person that he has just shot and killed. In exhibit number 3, Gage Grosskreuz's Facebook Live video, he tells a similar lie. As they're running, Mr. Grosskreutz asks the defendant, "Did you just shoot someone?" And the defendant says something about the police and then says, "I did not shoot anyone." And this is similar to the lie that he told Jason Lukowski at exactly that same time. As he passes Mr. Lukowski, he says, "I did not shoot anyone." And that was established through Mr. Lukowski's testimony. And again, I think it's worth emphasizing at this point that Jason Lukowski had just met the defendant maybe an hour. This is about 11:50 at night. Mr. Lukowski got there about 10:45.
Almost.
This is Gage Grosskreutz running towards danger, running to try and help. This is exhibit number 3.
Hey, what are you doing? You shot somebody? Who shot? Who shot? Hey, what are you doing? You shot somebody? Who shot? Who shot?
Listen to the second thing he says.
You shot somebody? Who shot? Who shot? Hey, what are you doing? You shot somebody? Who shot?
It's hard to tell what his exact words are. I hear the word "not" pretty clearly in there, as in I did not shoot anyone. I did not do anything. Jason Lukowski, he lies to. The crowd, he lies to. Gage Grosskreutz, he lies to. So at this point, the crowd is dealing with what they perceive to be an active shooter. Someone who has just shot someone, who is still in possession of the gun, who is fleeing the scene. And how are we supposed to know where he's going next? You know, all night that night, The crowd has been hearing the sound of gunshots. They've been hearing fireworks, firecrackers, but now someone actually has been shot. The crowd sees the defendant running with a gun. He's lying to them. He still has the gun. He's shot someone. This is provocation to them. This is someone who has committed a criminal act and is putting people in danger. It is entirely reasonable for that crowd to believe at that moment that he is a threat to kill again. The defendant could have made it unequivocally clear what he was doing. He could have stayed at Mr. Rosenbaum's body, helped protect him, helped preserve his life, call 911. As he's running, he could have announced to the crowd exactly what he was doing, told them. He could have fired warning shots to try and keep him away. He could have dropped the gun. He could have raised his hands in surrender. He could have signaled to this crowd that he did not pose a threat anymore. But everything he does is indicative of someone who is still a threat. Now, the defendant is going to tell you he wasn't. But from the crowd's perspective, how are they supposed to know any different? He does nothing to demonstrate to the crowd that he isn't a threat to kill again. And it turns out he does. It turns out within a few seconds, he does kill again. I submit to you, ladies and gentlemen, that in this situation, the crowd has the right to try and stop an active shooter. They have a right to protect themselves. The defendant is not the only one in the world who has the right to self-defense. But what does the crowd do to try and stop the defendant? I submit to you, and this is not a criticism of them, but they use almost the least minimal, least intrusive means possible. They could have used deadly force against him. They could have shot at him. But instead, somebody comes up behind him and knocks his hat off. Anthony Huber comes up with a skateboard and the defendant blocks it with his arm. And then the defendant falls to the ground on his own. No one knocked him down. This man that the defense wants to call jump kick man, he's got no weapons, no gun, no knife, no nothing, comes in and tries to kick the defendant in the face. Anthony Huber comes back and tries to grab the gun, actually does grab the defendant's gun and tries to pull it away because he's trying to disarm an active shooter. And Gage Grosskreutz comes running in, stops with his hands up in the air until he sees and hears the defendant adjusting his weapon as if preparing to fire again. And then what does Gage Grosskreutz do? He reaches for the gun to try and disarm the defendant. Gage Grosskreutz had his own gun in his own hand. He could have aimed it and fired at the defendant, but he did not. And you heard Gage Grosskreutz testify about that, about how that is a decision that he was not prepared to make at that point in time. He is not the type of person who is just willing to take someone's life in an instant, unlike the defendant, who took 2 lives that night very quickly and seemingly very easily. There is a video, Exhibit 5, which is the BG on the scene video, which traces this entire incident, which we call the second event. This is going to show you Mr. Huber, Mr. Grosskreutz, and the other individuals who are trying to stop an active shooter using what I would characterize as the least intrusive means possible. Someone knocks his hat off. Anthony Huber comes in with a skateboard. In just a few seconds, the defendant kills one person, attempts to kill 2 more, and blows off Gage Grosskreitz's arm. It's that fast. This is someone who has no remorse, no regard for life, only cares about himself. And these folks that are coming at him, the jump kick man, Anthony Huber, aren't armed. They're not a credible, imminent threat to his life. They are trying to stop an active shooter. And they have a right to do so. Imagine if the crowd couldn't do that. Imagine if they weren't allowed to try and stop someone in this type of situation. After killing Anthony Huber, after severely wounding Gage Grosskreutz, the defendant walks away like he's some sort of hero in a Western. Without a care in the world for anything he's just done. You know, it's interesting. This occurs about a block away from the police line, right down the road. If the defendant's so concerned about his safety, the police are right there. And in fact, they pull up to this scene almost instantly. The defendant's got his medic bag on. He proclaims himself a medic. He doesn't know at this point if Anthony Huber's dead or alive or capable of being saved. And yet the defendant offers no assistance, makes no attempt to try and help anyone else. All he cares about is himself. We have taken that video and we have broken it down into individual frames. And I want to take you through frame by frame the incident with Gage Grosskreutz, because a lot has been made about Mr. Grosskreutz's motions and what he does and where he goes and things like that. So I think it's helpful for us to take a look at this. So this is Exhibit 80, beginning with frame 356. At this point, you can see that Anthony Huber is staggering off after being shot in the chest. The wound has entered his lower left rib cage and has wound up almost exiting near his right shoulder. It has ripped through his ribs, his heart, his aorta, and he may not technically be dead, but he's going to be dead within a few seconds. He is stumbling away. The defendant has the weapon pointed towards Gage Grosskreutz here, who is cowering, hovering, hiding, covering his head, trying to stay out of the way. And I'm going to go frame by frame here slowly as we see the movement. Now we see the gun is moving down towards Gage Grosskreutz. It is pointed directly at him from a distance of just a couple of feet. Gage Grosskreutz has his right leg planted as if he's pushing backwards, trying to get away. The gun is still pointed at him. The defendant here is going to adjust the gun, turn it over as if he's making some sort of adjustment on it. Gage Grosskreutz testified that this was a movement that he interpreted as the defendant preparing that gun as if it was going to fire again, as if clearing a jammed round so that he could shoot it at Mr. Grosskreutz. At this point, Mr. Grosskreutz is, I think, probably thinking to himself, if I can get away, I will, until he realizes that the defendant is getting ready to fire again. In none of these frames is Mr. Grosskreutz's right hand with his Glock pistol pointed at the defendant. You can see Mr. Grosskreutz is actually backing up with his right leg. Let me go back a couple of frames here. This is frame 444. You can see his right foot is on the ground, but it's starting to move back. Now, as I move forward in the frames, 447, his right leg is moved back. This is someone who's about to retreat. His hands are in the air. He's backing away from the defendant. until, as he's testified, he sees the defendant start to manipulate that gun in such a way that it makes Mr. Grosskreutz feel like he's about to be shot. And only then does he take action. What action does Mr. Grosskreutz take? Does he hold that gun with both hands, the Glock that he's got, and point it at the defendant? No, never. Does he even take the gun with one hand and point it? No, never. Instead, you can see him start to lunge in with his left arm forward. The gun is not in his hand. The gun is in his right hand. He's lunging forward, reaching for the defendant, probably reaching for the gun, probably trying to block the gun. You can see now he's going to take a step with his right leg across the defendant's body, not directly towards the defendant, but across the defendant's body. As he's reaching in, almost swiping away at that gun with his left arm. He has bladed his body in such a way as to try and present as minimal of a target as possible, which is probably what saves his life. His right leg is about to hit the ground here. The gun, the AR-15, is pointed directly at him from just 2, maybe 3 feet away. He's trying to shield himself with his left arm. And as we approach frame 500 here, the gun goes off. At no point in this process is Mr. Grosskreutz pointing his gun at the defendant. Frame 499, the gun is just fired. Frame 500, you see the puff of smoke. 501, the bullet has hit Mr. Grosskreitz's right bicep, severing it. I'm going to continue forward after this because you can see that his right arm, this is an interesting frame right here, 504. You can see that gun. I'll go back even more. You can see that Mr. Grosskreitz's arm with the right hand, with the gun, his right hand is pointed off to the side. What pulls that gun down closer to the defendant is the fact that Mr. Grosskreutz just had his right bicep severed. It's not a voluntary action. It's an involuntary, the muscle is severed. Now watch, frame 502, watch his right hand. 503, 504, 505, 506, 507, 508. At this point, yeah, absolutely. That right arm is probably dangling down towards the defendant. It's not going to be able to pull that trigger without a working bicep muscle, and it's not a voluntary thing. It's done because the defendant just blew his arm off. But yeah, this is the time after the shooting when, yes, the gun happens to be pointed at the defendant. And I got to stop here for a moment and highlight the hypocrisy of the defense. Because according to the defense, if someone has a gun, they're a threat. If someone points a gun, they're a threat. There's only one exception to that. The defendant. By their logic, he gets to run around with a gun all night. But, oh, we're not supposed to take him as a threat. He gets to point the gun at everyone. But, oh, we're not supposed to take him as a threat. No, it doesn't work that way. The same set of rules apply to the defendant as everybody else. There's no exception in the law for Kyle Rittenhouse. There's no exception that says, if anyone else has a gun, you're a danger, except for Kyle Rittenhouse. There's no exception in the law that says, if you point your gun at people, oh, that makes you a threat and I can kill you, except for Kyle Rittenhouse. I can do it all night long. The same rules apply to him as everyone else. And everyone else has a right to defend themselves also, not just the defendant. We have shown you photos and videos of Gage Grosskreitz's injuries. Exhibit 60 is a video taken right after Mr. Grosskreutz was wounded by the defendant. It's hard to look at, but this is what we're dealing with. When you fire an AR-15 at someone from close range, this is what it looks like. I guarantee you, ladies and gentlemen, the defendant had no clue what his gun was capable of. He didn't even bother to pay any attention to it, didn't concern himself with what he would be doing to other people. But this is what happened. Let's not flinch away from this. It's important that we understand what that gun was capable of that night. It killed 2 people, and it did this to Mr. Grosskreuz's arm. When those shootings occurred that I just played for you, what would a reasonable person in the defendant's position at that time think? The good news is, ladies and gentlemen, you're going to tell us. As part of your decision in this case, you will represent the reasonable person, of ordinary and prudent person, and you will put yourself in the defendant's shoes that night. I submit to you that at the time of those shootings, a reasonable person in the defendant's shoes would have known that he had provoked Joseph Rosenbaum by pointing his gun at someone else, that the defendant had put someone else at risk of dying by doing that. The defendant should have known that the crowd was aware of the fact that he had just shot someone and that they felt their lives were in danger. That is reasonable. It is also reasonable to understand that at that point, Gage Grosskreutz had just witnessed all of this. He had heard the defendant had shot someone. He'd heard the defendant lie about it. He saw the defendant shoot at Jump Kick Man at close range, miraculously missing, had seen the defendant kill Anthony Huber. Gage Grosskreutz reasonably believed his life was in danger at that moment. And he was proven correct because the defendant shot him too. So when you consider what's reasonable in this case, consider whether or not it's reasonable for a criminal to be able to shoot himself out of a crime scene. When a bank robber robs a bank and runs away and the crowd comes after him, can he just shoot anybody and claim self-defense? If someone comes up to that person and tries to stop them, tries to disarm them, like Anthony Huber did, do they forfeit their life? Did Anthony Huber forfeit his life by trying to be a hero and stop an active shooter and protect others? Is that justified? Can the defendant just kill him? In this case, the crowd was right. The crowd knew the defendant had just shot someone. When they're coming after him, they know he's just shot and killed Joseph Rosenbaum. But you know, not every active shooter situation is the crowd have perfect knowledge. When they're told that person running up the street just shot someone, we don't have time in the moment to go back and take a look at the body and replay the video and make a decision before going after the person with the gun. You know, we've had several police officers testify that in an active shooter situation, their first instinct, their first training is to go in and stop the threat. They don't sit there and wonder, well, maybe it was self-defense. I don't know. I'm going to, wait and see. And every day we read about heroes that stop active shooters. That's what was going on here. And that crowd was right. And that crowd was full of heroes. That crowd did something that, honestly, I'm not sure I would have had the courage to do. If I see a guy running up the street with an AR-15 and I hear he just shot somebody, my first instinct is not to approach. Anthony Huber was different. Jump Kick Man was different. Gage Grosskreutz was different. That doesn't make them a threat to the defendant's life. It doesn't make their lives worthless. They don't give up their right to defend themselves. They have just as much right as the defendant. I told you I wanted to begin by talking about the murders committed by the defendant. Now I want to go back and put it all in context for you. And that context starts with, bruh, I'm just trying to be famous. The defendant's TikTok profile. 4 doors, more whores. Picture of him up in Ladysmith, probably in early May, proudly holding his new AR-15. Up until August 25th, 2020, this is the only time he'd ever fired that gun. Maybe put 100 rounds through it or so at that property up there with Dominic Black. They purchased that gun on that same trip. The defendant admitted he knew as a matter of law he could not buy that gun because he was only 17. Yet he wants to tell you that he thought legally he could possess it, which didn't make a lot of sense to me. We don't have a lot of defendants come in and say, well, I possess cocaine. I knew I couldn't buy it, but I thought I could possess it. No, it's not the way it works. Dominic Black conducted what we call a straw purchase for the defendant. He purchased that gun for someone who was not legally allowed to purchase it for themselves. I'm prosecuting Dominic Black for that, as you know, just like I'm prosecuting Joshua Zeminski. Because what Dominic Black did was wrong. And we don't tolerate that. The agreement was Dominic Black was going to keep that gun until the defendant turned 18. It was Dominic Black's gun. It was legally his. And the defendant knew that it was going to be held onto until he turned 18, that he was not going to have it until that birthday. I want to focus a little bit on this AR-15 because I think it's important when you consider the recklessness of the defendant's conduct, how much he knew, cared, or didn't know about this deadly weapon. He'd only fired it that one time, maybe 100 rounds through it. He loaded the gun with full metal jacket ammunition, which I'll talk about a little bit more. He wanted it because he said it looked cool. Didn't seem to know or care much about the type of ammunition or the type of gun. You had a couple of witnesses tell us in this trial, and I could not believe it. A gun is a gun is a gun. Don't even start with that. And a bullet is a bullet. No, it is not. It is not. And anybody who says that is ignorant and reckless, because there are some important distinctions here. Full metal jacket ammunition is capable of piercing body armor and squad cars. And you heard Officer Krieger testify that when they heard someone was running around with a rifle, he went and got his plate armor out of the back because their regular body armor wasn't going to stop those rounds. Ryan Balch talked about how full metal jacket ammunition is designed, and this is a former Army infantryman, is designed to go through a target like a deer or a person and continue on. He says it can hit a target 550 yards away. That's 5.5 football fields. And he explained that he had a handgun that night, which he put hollow point ammunition on. And that's what he was planning on using for self-defense. Because hollow point ammunition acts differently. It's going to hit its target, but it's not designed to continue on and go through and hit other targets. So you will hit what you hit, but you're not going to put the rest of the community at risk, especially on a night when there are hundreds of people out on the streets in a heavy residential area. We can see on that map, the car source, there are houses, there are churches, there are daycares, there are schools nearby, and you're firing full metal jacket ammunition around. I submit to you, ladies and gentlemen, that that AR-15 had no lawful or legitimate purpose that night. Now, the Second Amendment allows people to carry guns. That is true. There are people who can't carry guns, convicted felons, for example. But generally speaking, I'm not saying people don't have the right to carry a gun. What I'm saying is that AR-15 did not accomplish any of the goals that these folks said it was going to. So, for example, Ryan Balch says the handgun is what he was going to use for self-defense. Several witnesses agreed you can't point this gun or shoot this gun at people to protect property. So if you're going to protect the car source building, how is this gun going to help with that? The defendant has admitted The gun was useless when he was going to treat people as a medic because it got in the way. He had to take it off and hand it to someone. So you can't use it as a medic. You can't use it to protect the building. So what's it there for? Well, it looks pretty imposing and it has some deterrence value, but Jason Lukowski, Dominic Black, and Ryan Balch all said they never actually intended to use their guns. So why is it there? The defendant was wearing a sling that night. He purchased that sling at Jelinski's that afternoon. The purpose of the sling was so the gun couldn't be taken away, wouldn't fall off, he wouldn't lose possession of it. It was designed to help him retain possession of that gun. And he loaded it with 30 rounds, the full magazine, capable of killing 30 people or more. Why do you need 30 rounds of full metal jacket armor to protect a building? This AR-15 is completely incompatible with the role of a medic. Richie McGinnis testified he's been to demonstrations in Seattle, Portland, Washington, D.C., New York, Minneapolis. He's never seen anyone walking around claiming to be a medic with an AR-15. And certainly when you see someone like that, it doesn't exactly send a warm, fuzzy message. Oh, come to me, I'm here to help. And the defendant acknowledged he had to take off his AR-15 to treat people. No serious, credible medic wears an AR-15 slung around their body. That's because the defendant was a fraud. He was not an EMT. He lied. He lied to the press. He's being interviewed by Richie McGinnis, who he hears is a member of the media, and he says, I'm a certified EMT. You're lying. You're absolutely lying. Jason Lukowski and Dominic Black said the defendant had to borrow his medical supplies from us. This is an emergency situation. Everybody's anticipating violence. Everybody's prepared for people to be hurt, harmed, injured, and yet the defendant's going to go there and walk around claiming to be a medic? He's like a quack doctor practicing without a license. That puts lives at risk. And one of the things I had Gage Grosskreutz testify about is that tattoo on his right arm, which said, "First, do no harm," which is one of the precepts, one of the fundamental tenets of the practice of medicine. First, do no harm. So how do we evaluate the defendant's performance as a medic that night? Well, on one hand, he wrapped up an ankle and I think to maybe help somebody who got a cut on their hand. Yay. On the other hand, he killed 2 people, blew off Gage Grosskreitz's arm, and put 2 more lives in jeopardy. So, you know, when we balance your role as a medic that night, I don't give you any credit. He showed no remorse for his victims, never tried to help anybody that he hurt, and even on the witness stand, when he testified on Wednesday, he broke down crying about himself, not about anybody that he hurt that night. No remorse, no concern for anyone else. For him to call himself a medic is an insult to anyone like Gage Grosskreutz, who spent hundreds of hours training and working hard to become an EMT. It's an insult. The defendant made a series of reckless decisions that night, going armed with an AR-15 at 17 years old when he knew he shouldn't have done so, because that gun is normally locked in a safe that he doesn't have access to, and it's not even legally his. He's out after a citywide curfew. He's intentionally and knowingly entering into a dangerous situation, and he expects it because he brings along his AR-15 and some body armor. So don't tell me you didn't know. He brings along no non-lethal means of defense, which means his only option is to kill. I don't know about a lot of you, but I remember that night. I didn't come down here. I don't think most reasonable people did, in part because we all knew it was going to be violent and dangerous. Most reasonable people, to the extent they came out, they were gone by then, because you don't willingly put yourself in this situation unless you want it. unless you're looking for it, unless you want trouble. Now, to put this in perspective, at this time here in our community, there were people who were scared. There were people who were worried about themselves, their homes, their families, their business. That's understandable. But this is different. There are also people out there who were exercising their First Amendment right to assemble and to have free speech because of whatever they believed in. And they have that right too. But that's not what we're talking about. The curfew, the riots, the arson, the looting that we'd seen on those prior nights, roadblocks set up around downtown, closed exits on the interstates, all of this was sending the message to reasonable people, go away. Don't come down here. Who was left at 11:45 at night? Most reasonable people had gone home before the curfew or never even came at all. But the defendant's down there, he says, because he wants you to believe he's protecting CarSource, even though he had no actual ties or genuine concern for this building. You have this caravan of people from West Bend, Ryan Balch, Jason Lukowski, Joanne Fiedler, coming down from some other community, having no idea what's going on here, Kenosha, having no idea what businesses are, having never dealt with CarSource before, just injecting themselves into this situation. CarSource that night was empty. The owners testified. They moved all the cars off the lot. They took the tools out from inside, and they didn't even feel the need to protect that building. So who's there? These guys with their AR-15s are just wannabe soldiers, acting tough, trying to manufacture some personal connection to this event, furthering their own personal agenda. Just a small part of the deluge of chaos tourists we saw here in Kenosha, trying to feed off of what we were going through. Despite everything we did to try and tell them, go away, stay out. Did those owners, Sam and Sal, ask anyone to protect their business? You know, I called them to the stand because I wanted you to hear from them. I had their statement, but I wanted you to hear from them. And I'm sure you formed your own impressions about them. I'm not here to tell you that I believe what they said on the witness stand. I don't think it really matters much, except I wanted you to have a flavor of who these people were and what was going on at that building. What was interesting to me is that text message from the defendant to Sam asking for the address of CarSource, even though the defendant says he's already been there. It didn't make any sense to me. It's not hard to find if you've driven past there every day. You know, Kenosha is one of the easiest cities in Wisconsin to navigate. It's all east, west, north, south. How hard is it to find this place? But the agreement was the defendant was supposed to stay at the 59th Street location. There's another group at 63rd. It was their responsibility. And the defendant testified that when the shootings occurred at 11:45 or 11:50 at night, he didn't even know if that other group was still there or if they'd left. But crucially, you heard the testimony of Kriston Harris, who's out there reporting for his Rundown Live, and he's making some video. And he tells the defendant, stay on your property. Don't go out in the streets and engage with these protesters because you're just making it worse and you're escalating the situation. He tells the defendant specifically that, just 20 minutes before the shootings. Kriston Harris probably said that because he knows this is a crowd that is feeling threatened by the defendant and his group. Richie McGinnis testified when he left the Stella Hotel and immediately ran over to 59th Street, he saw guys up on the roof and he felt threatened. These guns, he said, were the thing that changed the dynamic for him. Drew Hernandez, we showed video of Drew Hernandez having laser sights pointed at him. And he said he felt threatened. He thought someone was pointing a gun from the roof and putting his life in jeopardy. These are two people who are veterans. They've been to protests in Seattle, Portland, Washington, D.C., New York. They've been through this before. And yet here in little old Kenosha, the defendant's group made them fear for their lives. That's the kind of impact these AR-15s had. The crowd is yelling at the defendant's group, stop pointing your guns at us. Stop pointing these laser pointers at us. And the defendant sees this. He's well aware of the fact that the crowd out on the street is hostile. They don't react well to him. And he knows that by 11:35 at night, this crowd is all the way down there south of 60th. That's where they're at. So if I go down there, I need to be prepared, and I need to expect that these folks are not on my side. Joseph Rosenbaum. He's dead. So we don't know what he was thinking. We don't know what was going on in his mind. That makes him an easy target for the defense today, because they can stand up here and pile on him and destroy his reputation, and he can't speak for himself. That happens a lot in homicide trials. Blame the victim who can't speak for themselves. So I'm going to tell you a little bit about Joseph Rosenbaum, and you've heard some testimony about him. He had been in the hospital, left it that day, had a clear plastic bag with his possessions, toiletries, a water bottle. We've all seen this. You get it in the hospital. It's pretty common. He's walking around like it's pretty much his only possession in the world. He visits Carrie Ann Swart, his girlfriend, and then happens to wander downtown into the middle of civil unrest. No indication he planned to be there. No indication he's part of any sort of movement. He just happens to stumble into it. So what does he do that night? Oh, let me tell you all the awful things Joseph Rosenbaum did. He tipped over a porta potty that had no one in it. He swung a chain. He lit a metal garbage dumpster on fire. Oh, and there's this empty wooden flatbed trailer that they pulled out in the middle of the road, and they tipped it over to stop some bearcats, and they lit it on fire. Oh, and he said some bad words. He said the N-word. If he were alive today, like Joshua Zeminski, I'd probably try and prosecute him for arson, but I can't because the defendant killed him. But that's the way we deal with people that do these things. When you commit arson, we prosecute you. We don't execute you in the street. And I'm not here to say that the things that Joseph Rosenbaum did were good or that I condone that kind of behavior. Not at all. But he didn't deserve to die for it. You can't kill someone for these things. He's 5'4", 150 pounds. Jason Lukowski characterized him as a babbling idiot. Lukowski says, I turned my back and walked away. This guy wasn't even a threat. I think we all know somebody like Joseph Rosenbaum, the Napoleon complex, the little guy who just wants to chatter. But when it comes down to it, it's all bark. It's no bite. It's like a little dog. Bark, 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 bark. But really ain't going to do anything. There is no dispute in this record that at no point that night did Joseph Rosenbaum hurt anyone. Never had a gun, never had a knife, never had a bat, never had a club. And in the Drew Hernandez video, that fight at Ultimate Gas that we showed you, he's being shoved around by the crowd like a rag doll. And yeah, he's mouthing off, he's talking a lot, but he doesn't actually threaten anybody, doesn't actually hurt anybody. They're pushing him around like he's a tiny little person, which, frankly, he was. And in the background of this video, you will hear somebody say, point your gun at me or something like that. That's Joseph Rosenbaum. He's upset because somebody pointed a gun and that triggers him, which is understandable. I think most of us would be triggered by that sort of thing. And that's what's upsetting to him. But he gets right in the face of people who have AR-15s, never reaches for their guns, never rears back to punch anyone, never even lays hands on anybody. Confrontation here at Ultimate Gas, and I want you to keep in mind that there's a group of people on one side with AR-15s and a group of people on the other side, and none of the people with the AR-15s feel their life is in danger. None of them shoot their guns. They can handle themselves. The defendant can't. That sound you heard was somebody throwing some sort of plastic thing at one of the stanchions underneath the gas station, and it makes a sound that almost sounds like a gunshot. So add that into the mix. You've got people with guns, loud voices, clear hostility, and the sound of something that, frankly, to me sounds like a gunshot, and yet everybody keeps their cool. Nobody hurts anybody. Nobody fires a gun. And watch how they push Joseph Rosenbaum around like a rag doll. Watch this guy in yellow. He's going to shove Joseph Rosenbaum about 8 feet away. Guy that did that, but they're shoving him around like a rag doll. Nobody feels threatened by Joseph Rosenbaum. He's not reaching for anybody's gun. He's a mouthy little guy. He's a little dog that and grab his bag off the ground. That's Joseph Rosenbaum. You've heard testimony that he tells people, shoot me, asking them to shoot him. I'm curious how that's a threat to anyone else. He's triggered, as we saw in that video, by people pointing guns at other people, which is reasonable. Most people would feel that same way. And then we get to the crux of the defense, this threat that he supposedly made to the defendant. The defense would love to be able to play you a video of this threat. They would love for you to see it and hear it yourself. This is a night in which there are dozens of people out there, reporters and regular folks who are recording with their cell phones and with other cameras all night long. We have shown you video of almost every minute of the defendant's night from multiple different angles. And yet you have not been shown a single video with this threat. Nowhere. It's not out there. Ryan Balch testified, and we have his transcript. We have his testimony, and what he says is there was an incident in which Dustin Collette had put is right there in front of my face yelling and screaming, and I tell him to back up, and he goes, you know what, if I catch any of you guys, blah blah blah. So that's the timing, according to Ryan Balch, right after that dumpster fire. Kriston Harris from the Rundown Live was there, physically, standing right next to Ryan Balch. Not only was he there during the dumpster fire, but he stays with Ryan Balch and or the defendant for the next 6 or 7 minutes, recording everything. And I've played this video for you. It is Exhibit 18. And I played for you a period of time from 1 hour and 22 minutes to 1 hour and 28 minutes. And I asked Kriston Harris, I call him to the stand, and I said, I'm going to ask you 2 questions. Number 1, do you independently remember seeing Joseph Rosenbaum, hearing this threat? And he said, no. And then I said, okay, well, maybe you missed it because, you know, there's a lot going on. So will you rewatch your video for me and tell me, is it in there? And he said, no. This video captures that entire period of time with Ryan Balch and the defendant right there, and there's no threat. There's no Rosenbaum. It didn't happen. The defense desperately wants this because they've got to give you a reason why it's okay to kill Joseph Rosenbaum. And this threat is critical to their case. But it's not there. In exhibit number 3, and I'll play it for you here as I'm talking. Joseph Rosenbaum isn't even visible. Now, I submit to you that even if, I'm sorry, this is exhibit 18, even if there was a threat made, it's still not enough because Joseph Rosenbaum's unarmed and you can't kill him. But the defense has pinned a lot of their case on a threat that didn't happen and they can't prove. It's not on video. It's not there. So I'm going to pull up exhibit 18, the rundown live video, and I'm going to go to that mark.
Kristan T. Harris here at the Rundown Live, and I'm here with a bunch of
Joseph Rosenbaum isn't here. And the defendant and his group are being told an important message. As long as you stay on your property, but don't go out there and cause trouble.
Thanks, guys.
The rest of the video is the crowd being warded off by gas launched by the police. They launch tear gas, which affects the defendant, it affects Ryan Balch, it affects Kriston Harris. And that group all runs alongside the 59th Street car source, away from the street, away from any protesters. At no point in that video do you hear any threat that Joseph Rosenbaum makes. It's not there. Trust me. If the defense had it, they'd play it for you. Now, they want you to believe that that threat is made, and they also want you to believe that it was something that the defendant took into account when he decided to kill Joseph Rosenbaum. One of the questions that occurs to me is, how would the defendant even know who that guy is? Because earlier in the night, Joseph Rosenbaum is wearing a red shirt and a blue bandana. But by the time he's killed, he's got no shirt on. He's got no blue bandana. This is someone the defendant has never even met before. He's one of hundreds of people in the crowd. And yet we're expected to believe that in a split second, the defendant remembers this guy? I don't believe so. So then that video that I just showed you leads off at about 11:35 p.m. The police have moved the protesters south of 60th Street. They've tear gassed the crowd, and there's no protesters left. 59th Street is no longer in any danger. It wasn't much danger to begin with. There wasn't anything left there to protect. But by this point, there's no more danger. As law enforcement comes through, you've heard this video where they tell the defendant and his group, "We appreciate you," and hand them out bottles of water. As long as you stay on that private property, yeah. No one is saying you don't have the right to stay on private property and protect private property. What people are saying, what the crowd is saying, is stay there. Don't go out looking for trouble. The defendant hears this message from the police and takes it the wrong way. He thinks, oh, well, now I'm junior policeman. I can go run around stopping crime. But I asked him and I asked some other witnesses, if the police are there on the scene and the protesters are gone, go home. Why are you still here? Shouldn't have been here in the first place, but why are you still sticking around? And interestingly enough, one of the questions I've always had in the back of my mind is, what's the end game here? When is this crew going to be done and decide that it's time to leave? Well, right after the defendant kills Joseph Rosenbaum, kills Anthony Huber, and comes back, they all flee like rats off a sinking ship. But it's boring at 59th Street. There's no protesters. There's no action. So the defendant decides about 11:35 p.m. to cross the police line and go looking for trouble. He knows at this point he's entering a hostile crowd. He's seen this crowd. He knows what they're like. That's why he has to yell friendly to them, because he knows they're not going to see him and think he's friendly. And he knows he's got to have Ryan Balch with him, some sort of buddy to protect him. And he's immediately confronted by that man with the yellow pants who says, "You just pointed your gun at me." And the defendant says, "Yeah, I did." He admits that. Now, what's interesting to me is they want you to believe this never happened. They want you to believe this guy in the yellow pants made it up or is lying. But he's just standing there by the side of the road, minding his own business, when the defendant happens to walk up to him. Do you think he just sat there and thought, oh, I'm going to make up a lie about this guy on the spur of the moment? Or did it really happen? And is it consistent with everything else you've seen about the defendant? Does he sound like the sort of guy who would point a gun at someone for standing on a car? Does he strike you as the kind of guy that would threaten deadly force to protect property? Because that's what happened. The man in the yellow pants says it happened. The defendant agrees. And then he comes into the trial and says, oh, I was being sarcastic, like he's a little 17-year-old and he wants to get out of it. Shortly after that, the defendant loses track of his protector, Ryan Balch. So now he's in a position where he knows that he's surrounded by people that consider him a threat. He knows that he's not supposed to go anywhere without Ryan Balch. He knows he's supposed to go back to 59th Street. And he does. He tries. He walks up to the police line. He says, I work there. That's my business, which isn't true, but whatever. And they won't let him through. Now, Ryan Balch makes it on through shortly thereafter. But the defendant gives up. He could go one block in either direction and make it back easily if he wants to, but he stops and decides, you know what, I'm going to stay here and maybe see what's going to happen. So then he talks to these people with fire extinguishers, and he's going to go down to 63rd Street, and he asks one of them to come along, and they say no. Now at this point, doesn't have Ryan Balch. He knows he's supposed to go back. He knows he's supposed to have a buddy, and yet he decides to go it alone. He decides to run down to 63rd Street or walk down to 63rd Street. Doesn't even know if that other group is still there. Doesn't even know if he's really needed, but he can't wait to take this opportunity to go down and confront people. Because he thinks he's some sort of cop, some sort of law enforcement agent, some sort of junior cadet who's out there with the responsibility to fight crime. Nobody asked him to do that. Nobody gave him the right. Nobody deputized him. Ryan Balch says, the police told me the crowds, we're going to push them down by you. You're going to deal with them. The Bearcats hand out water and tell him he's appreciated. As he's crossing the police line, they warn him about people throwing rocks. What is the message the defendant takes from all of this? The wrong message. Oh, well, now I've got the power. I've got the gun. I'm going to go confront these bad guys. I'm going to stick my nose in things. So what does he do when he gets down to 63rd Street? The first thing he does, we showed it to you at the very beginning, that drone video, grabs that gun and points it at someone to protect property. Points it at the Zeminskis. Because why? Because they're what? About to mess with some sort of fire? They're not threatening anyone's lives. He doesn't need to protect anyone. He doesn't need to protect himself. He's pointing a gun because he thinks he needs to protect property. He says he wants to put out a fire, but the first thing he does is drop the fire extinguisher on the ground. His AR-15 isn't going to put out a fire. So why is he really there? And we all agree, you can't use or threaten deadly force to protect someone else's property. You are here to decide whether or not his actions are legally justified, not to buy pathetic excuses that might be given to you. As a teacher, when a student says to you, the dog ate my homework, that's an excuse. It doesn't get you out of the homework assignment. If you panic in a situation that is not reasonable, that is an excuse. It is not a legal justification. If you're 17, if you don't have training or experience, if you put yourself in a situation where you're in over your head, if you're scared, those are excuses. Those are not legal justifications to kill. They do not erase your personal responsibility for your own actions. The court has read to you the instructions in this case. They lay out the law that you should apply. That reading took a long time, and I understand there was a lot to digest. And one of the things that you will have the opportunity to do when you go back and deliberate is read through those instructions yourselves. Because I get that listening to them doesn't always make it clear. But I encourage you to focus on some things when you consider the defendant's behavior in this case. You are told that criminally reckless conduct is conduct that threatens other people's lives and poses an unreasonable and substantial risk to other people. There is no dispute the defendant's activities here threatened other people's lives. He took 2 lives. You know, this is not like a normal murder case. A lot of murder cases we're in here trying to convince a jury that the defendant killed somebody. That's not in dispute here. That's the easy part. The question is, does he get a pass? Do we think that's okay? Do we think what he did was right? That's the question you have to answer. And when you consider whether his conduct was criminally reckless, consider, did it pose an unreasonable and substantial threat to the safety of others? Count 4 charges him with first-degree intentional homicide of Anthony Huber. There is no doubt that the defendant intended to kill Anthony Huber or committed conduct that he knew was practically certain to kill Anthony Huber. That gun was pointed at Anthony Huber's lower left rib cage, and the defendant deliberately pulled the trigger. That was no accident. And when you do that with an AR-15 against someone's body, it is practically certain to kill. We all know this case comes down to self-defense. But there's a high bar for using deadly force in a self-defense situation. The law says that the defendant may intentionally use force which is intended or likely to cause death or great bodily harm only if the defendant reasonably believed that the force was necessary to prevent imminent death or great bodily harm to himself. So did Joseph Rosenbaum pose an imminent threat of death or great bodily harm to the defendant? No way. Did Anthony Huber pose an imminent threat of death or great bodily harm to the defendant? Absolutely not. Did Jump Kick Man or Gage Grosskreutz? No. None of these people posed an imminent threat to the defendant's life or to cause great bodily harm. The standard when you make this decision is what a person of ordinary intelligence and prudence would have believed in the defendant's position under the circumstances that existed at the time of the alleged offense. The reasonableness of the defendant's beliefs must be determined from the standpoint of the defendant at the time of the defendant's acts and not from the viewpoint of the jury now. So put yourself in the defendant's position. Would you have done the same thing? Would a reasonable person have done the same thing? Would you have engaged in the reckless conduct that led to this course of events? Would you have gone out after curfew with an AR-15 looking for trouble? Would you have aimed at other people? Would you have tried to use the gun to protect an empty car lot? No reasonable person would have done these things. The court has also instructed you on provocation. You cannot hide behind self-defense if you provoked the incident. If you created the danger, you forfeit the right to self-defense. By bringing that gun, aiming it at people, threatening people's lives, the defendant provoked everything. And if he does that, he has to exhaust all reasonable means to avoid a confrontation. All reasonable means. So if Joseph Rosenbaum's running at him, Joseph Rosenbaum is no threat to his life. And not only is the defendant expected to run, he's expected to yell, push, shove that rag doll around, run back for help, call 911, call for help, do all sorts of other things besides just turn and fire 4 shots as Joseph Rosenbaum falls helpless to the ground. Ladies and gentlemen, there is no doubt in this case that the defendant committed these crimes. He committed a first-degree reckless homicide against Joseph Rosenbaum. He put Richie McGinnis's life in jeopardy. He put Jump Kick Man's life in jeopardy. He intended to kill Anthony Huber, and he attempted to kill Gage Grosskreutz. All of those elements are true. The question is whether or not you believe that his actions were legally justified. And I submit to you that no reasonable person would have done what the defendant did. And that makes your decision easy. He is guilty of all counts. Thank you.
Thank you, Mr. Mayor. Let's take a break and about 2:25, hopefully. And please don't talk about the case. Read, watch, or listen to any kind of a trial.
Good afternoon. I'm Ashley Wilcott with you from 3 to 6 today. Well, you can just hear the prosecutor has rested in the closing statements in Wisconsin versus Kyle Rittenhouse. Of course, they'll have an opportunity to do a rebuttal as well after the defense's turn. We're going to take a short break. We'll be right back on the other side. Court TV Live. Welcome back to Court TV Live. I'm Ashley Wilcott. Always my pleasure to be with you. So glad that you've joined us. We want to just mention two big trials that we're covering here on Court TV. The first that we've been watching closing arguments is Wisconsin versus Kyle Rittenhouse. This is the case in which he's accused of actually purposely killing two individuals rather, and injuring one, versus his position of it was self-defense and therefore should not be found guilty. We're also keeping an eye on the trial, again, the killing of Ahmaud Arbery, 3 defendants in that case in Brunswick, Georgia. Now, first, the closing arguments by the state have finished. The defense will go next, but because of that, in Wisconsin, the court has taken a break. While we have that break, we want to bring in an opportunity to bring in family law and trial attorney Peter Stambleck from New York. Peter, thank you as always for joining us here on Court TV Live. Tell me, first of all, your overall impressions of the prosecutor's closing argument.
Good afternoon, Ashley. It's nice to see you again. I think he did a very, very nice job of summarizing his case. I think that he was very efficient with his time. I thought the PowerPoint presentation was spot on. He was methodical. He applied the facts that were brought out through the direct examination and his cross-examination of his case. He applied those to the law and the jury instructions that were given to the jury earlier this morning. And I thought he did an excellent job of doing what he needed to do in order to make it understandable for the jury to recap everything that had gone on for the past 2 weeks.
Right. And I just must ask, and one of the things I want to mention that you and I are going to talk a little bit about later is I wonder how much he's really going to focus on his rebuttal, because he certainly still has time left. And we know, I would expect that he's going to do a rebuttal. But stay with us, Peter. We're going to keep breaking it down. I welcome and value all of your expertise. But also joining me now, I have Court TV legal correspondent Chanley Painter, who is live in Kenosha to help us break down today's events and what's happened so far. So Chanley, first of all, always great to see you. Thank you for being with us. And tell us, during the state closings, what is the color of the courtroom like inside that courtroom as this jury is listening?
What a morning it has been inside the Kenosha County Courthouse behind me. First thing, the jurors, all 18 of them, attentive. Now, what's different today from any other day is they don't have their notepads during jury instructions or during the closing arguments, and that's standard for this judge because, as we know, arguments are not evidence, but they are completely engrossed, especially during moments where Prosecutor Binger is playing key pieces of video, walking them through methodically, almost a matter-of-fact tone. Unlike a lot of prosecutors we see here on Court TV that come out with very passionate, heated arguments from the beginning and closing, that's not so much ADA Thomas Binger, but he seems to be going at a pace that is easy for the jury to follow, ultimately arguing over and over again so far today that Kyle Rittenhouse was the initial and only aggressor on the night of August 25th, 2020. And there was a key dramatic moment when he talked about the exchange between Joseph Rosenbaum and Kyle Rittenhouse. Let's watch.
The defendant comes running in and drops the fire extinguisher on the ground like this. And then raises his left hand to the gun and points. This is what we see in the video. Him putting the fire extinguisher on the ground and then raising the gun.
Your Honor, I'm going to object. He's facing the wrong direction.
That's an argument.
Okay.
I'd like to actually have, well, I'll leave it alone.
So what you see in that video is his left arm reaching for the gun, holding it up. You can see it again on the video here. His left arm reaching up towards the gun. That is what provokes this entire incident. And one of the things to keep in mind is that when the defendant provokes the incident, he loses the right to self-defense. You cannot claim self-defense against a danger you create.
Now, inside, the video is grainy. It's difficult to see, but jurors were scrutinizing. They were craning their necks, leaning up in their seats, going frame by frame with the prosecutor, trying to see what they were pointing out at that moment when they allege Kyle Rittenhouse provoked the chase with Rosenbaum. Also, outside the courthouse where I'm standing right now, tensions are rising. We have more demonstrators on the steps of the courthouse today, Ashley, and we also know that the governor has called in the National Guard to be on standby for anything that may happen this week.
All right. Two things, Chanley, I'd love to ask you about before we move on to the next topic. One is, we know that closing argument is all about convincing the jury. These are the facts that you've heard, and this is what they mean, and they fit in my narrative in this case. I thought that the prosecutor did a very effective job of saying, these are the facts. Look at that video. This is what's happening. And then saying, this is what the law means. You must convict on all counts. At any point, did the jury seem to really stop listening to him during his opening or kind of lose focus? Or do you think they were intent the whole time?
Well, there's always the after lunch lull, actually, that we see inside courthouses when the jury returns from a lunch break. It's the afternoon. It's been a long day of a lot of listening. You can see those moments, but because of the pace of Thomas Binger and the fact that he's repeating, primacy and recency, as we study in law school, when you deliver opening or closing, you repeat provocation, you repeat certain language and themes of your close. We can see him doing that inside the courtroom, and that makes this more effective along the lines to follow. And there's nothing really overt from jurors. So far today, the only thing that has been stand out when the prosecutor showed the graphic photo of Gage Grosskreuz's arm virtually blown off, the entire court, you could hear an audible gasp inside the courtroom, because remember, inside the gallery, more people than have ever been in the courtroom have been in during this case today. I mean, it is standing room only inside this courtroom, so a lot of them have not seen the graphic photos, unedited, of not only Gage Grosskreutz, but of Joseph Rosenbaum, Anthony Huber, that this prosecutor is putting on the screen, and it was an audible gasp in that moment. Many people in the gallery, of course, looked away, but also jurors who've seen these photos before also averted their eyes from those screens during those moments.
Wow, so much going on there. Tell us a little bit more about the demonstrations outside of the courtroom. You just said those are picking up. What type of demonstrators? Are there different groups on different sides of a sidewalk, or can you really tell?
Well, they're all gathered. I don't know if you can see behind me, but there's a group with signs on the courthouse square, and they aren't really separated, actually, which is interesting in this case. You hear countering chants and protest at times, but you can tell the difference of who's supporting what based on the sign that they're carrying. So we see signs both in support of Kyle Rittenhouse outside the courthouse here, also inside the courtroom, and for justice in this case against Kyle Rittenhouse and for the alleged victims here. Occasionally we will hear chanting from where I'm standing, and people drive by in their cars and will yell chants or yell phrases out here by the courthouse as well. It's definitely a different vibe and scene today than we've seen the entire trial.
All right. Always appreciate your descriptions because they're so thorough, and it just makes me feel like I'm actually there with you. Let's move, if we could, to a count that viewers have all consistently kind of said, well, this is one he's guilty of, regardless of which version of facts you believe. And that's count 6, possession
lesser included when they determined whether Rittenhouse acted in self-defense and how that would streamline their deliberation process. He sent them out of the room briefly and had a moment with the attorneys to talk about exactly what he wanted to clarify. Let's take a listen.
Folks, what I was talking about with the cases that you have multiple possible verdicts submitted to you for consideration, when you address the charged crime, if in your discussions you conclude that the elements are present and the defendant was not acting lawfully in self-defense, then you needn't go any further. You can return your verdict of guilt based upon that conclusion. If in your discussions as to any individual count of those with multiple possible verdicts, in your initial discussion, if you decide that the defendant acted lawfully in self-defense,
her boyfriend suffocated inside of a suitcase.
She could have let him out. She could have saved his life.
free movie channel has something for everyone. Find your new favorite movie tonight.
Newsy Tonight is changing the conversation.
Incredible footage coming in live right now.
Primetime news focused on facts.
We're not really as divided as it may seem. Let's break down our latest Newsy poll.
Newsy Tonight, weeknights at 8, only on Newsy.
This is true crime all the time.
We continue our gavel-to-gavel coverage.
We are live in courtrooms across the country.
This is what I love to do.
All children deserve a chance to succeed. When you give a child a book, you give a child a chance. On behalf of the Scripps Howard Foundation and the If You Give a Child a Book campaign, we would like to thank Kellogg's for supporting our mission and their generous donation of 35,000 books. Thank you for providing the gift of reading for children who need it most. Text BOOK to 345-345 to give today.
Welcome back. Thank you for joining us. We are still in live coverage of Wisconsin versus Kyle Rittenhouse. What that means is we will take you back to court as soon as it begins. The jury was given a break. They're back in the courtroom waiting on the jury to come in. We don't yet have audio, meaning it's not yet on the record. I may have to cut you off, Peter Stambleck, but still with me, family law and trial attorney. I appreciate you sticking around. Let me ask you this, because one of the burning questions a lot of viewers are posting and talking about is the pending motion for a mistrial in this case that the defense made, but the judge hasn't ruled on. What do you expect? Will we hear from the judge on that, in your opinion?
I do. I think he will rule on any pretrial motions, including the motion to dismiss prior to the sending the jury out. And I suspect that the ruling will be